While we are waiting for Mr. Nigam to join, very warm welcome and good morning, Shri Ravi Mittal, Chairperson, Insolvency and Bankruptcy Board of India, Mr. Shardul Shroff, Chairman CI Task Force on Insolvency and Bankruptcy, and Executive Chairman Shardul Amarchand Mangaldas and Co. Dr. Ashok Haldia, Chairman, Indian Institute of Insolvency Professionals of ICAI, Mr. Vijay Kumar Iyer, Partner, Deloitte India, Insolvency Professionals LLP, Mr. Siddharth Nigam, Partner, Grant Thornton Bharat LLP will be joining us. Senior officials from IBBI, esteemed speakers and panel members of various technical sessions of the conference during the day, ladies and gentlemen. I extend a very warm welcome to all of you at the CII conference on Insolvency and Bankruptcy Code today. I extend a special welcome to Shri Ravi Mittal, Chairperson IBBI, who has kindly consented to be the chief guest this morning. Thank you, sir, for joining us today. Under your able leadership, sir, IBBI has been proactively responding to further strengthen the insolvency framework and make the processes under the code more efficient and effective by streamlining issues during implementation. The government has initiated dialogue and announced key amendments to the code and regulations, due to which the code is hailed as one of the most important economic reforms of the recent times, which has been guided by government's vision of making doing business easy in the country. A sincere thanks and very warm welcome to you, sir. I would also like to welcome our esteemed speakers on the dais for the inaugural session of the conference, Mr. Shardul Shroff, Chairman CI Task Force on Insolvency and Bankruptcy, and Executive Chairman Shardul Amarchand Mangaldas and Co. Mr. Shroff is key member of the two important Government of India committees amongst many, that is Insolvency Law Committee and Company Law Committee. Both continuously review the laws of insolvency and the company law of India, which are very important to the legislative reforms in the country and help simplification of laws. Mr. Shroff spearheads the CI initiatives under the IBC as he chairs the CI IBC committee and advises on the framing of legislation, enabling a balance so as to reach a consensus between the industry and the government. A very warm welcome to you, Mr. Shroff, and thank you for your support to CI. Dr. Ashok Haldia, Chairman, Indian Institute of Insolvency Professionals of ICAI. Dr. Haldia has been a member and advisor on a number of committees appointed by Government of India. Dr. Haldia is deeply involved with CI on regulatory affairs, financial reporting, and many other important areas of work. It is a pleasure to have you, Dr. Haldia, with us today. Mr. Vijay Kumar Iyer, a partner with Deloitte India Insolvency Professionals LLP. Mr. Iyer has been involved in successfully delivering several of India's largest insolvency and restructuring matters. Welcome, Mr. Iyer. Mr. Siddharth Nigam, partner, Grant Thornton Bharat LLP. He is also a national managing partner, clients and markets, and members of strategic leadership team. Mr. Nigam, I am sure you with your experience in investment banking and strategic consulting across India and the UK, you will have a global perspective to share with our members today. Welcome to the conference. Ladies and gentlemen, we all know that IBC has played a very important pivotal role since its inception in 2016 in ensuring a healthy credit flow and generation of new capital for businesses which turn insolvent, or for businesses which were on the verge of turning insolvent but saved due to the IBC process. IBC has brought about a key behavioral change from debtors in possession to creditor in possession. This has tremendously helped stepping up economic activities and ease of doing business in India. It is but natural that the evolving law that IBC is faces challenges on both operational and legal front, and here I would like to highlight the role of the guardians of the IBC, the Ministry of Corporate Affairs as well as the IBBI, which have done a commendable job in supporting industry in overcoming the challenges, be it providing greater autonomy or bringing in amendments to enhance conduct or improving timelines or value maximization in corporate insolvency proceedings. It is due to these sustained efforts by MCA and IBBI that India has significantly improved its ranking in ease of doing business. Further, in a recent statement, the Honorable Finance Minister has also stated that government is considering further amendments in IBC to address the requirements of the industry, and changes to the code are being considered in relation to the admission of corporate insolvency resolution process applications, streamlining the insolvency resolution process, recasting the liquidation process, and the role of service providers under the code. CI has been engaging extensively with the government in suggesting reforms and suggestive measures to make the code and regulations more robust. Till date, detailed submissions have been made on the law to MCA and IBBI. CI has also submitted a set of provisions that may be considered to be decriminalized in the IBC code. We have also been conducting seminars and conferences regularly to promote stakeholder interactions for furtherance of IBC agenda. On behalf of CI, we would like to reiterate our support to the government, the Ministry of Corporate Affairs, and IBBI in its endeavor to strengthen the functioning of the IBC by way of policy inputs and stakeholder interactions. We shall continue to take up issues related to ease of doing business to shape an environment that encourages investments and growth, and look forward to taking this endeavor ahead in partnership with the government. With these words, I once again welcome you all to this conference with the theme Insolvency and Bankruptcy Code, Evolving Paradigms and Reforms. I also want to thank the Insolvency and Bankruptcy Board of India, the Indian Institute of Insolvency Professionals of ICAI, the National Foundation for Corporate Governance for supporting the conference, and also to our sponsors, which are Deloitte, Shardul Amarchand Mangaldas, Khetan, JSA, and Sarthak Advocates and Solicitors for all the support. And may I now invite Mr. Shardul Shroff, Chairman CI Task Force on IBC, and Executive Chairman Shardul Amarchand Mangaldas and Co. for his remarks and to moderate the session, please. Thank you.
Honorable Chairman of IBBI, Sri Ravi Mittal, distinguished panelists for the conference, and friends. We are gathered here to confer on the IBC 2016, which is nearing 7 years of experience before the end of the year. We are evaluating the evolving paradigm of this comparatively young legislation in a time frame against more matured regimes of the West and now of the East too. There are 3 plenary sessions besides this inaugural session for an in-depth discussion on vexed questions which have engaged the minds of the regulator and the Ministry of Corporate Affairs. I have been blessed and I'm lucky to have had a ringside view in several capacities, first as a thinker and evaluator, an aide to the legislation, and a practitioner of the IBC law. I would limit myself to 5 themes out of the several themes which are up for discussion today. Firstly, the imbalance between the equally emphasized timely resolution and value maximization. The doctrinaire approach emerging from the preamble and the statute. The necessity of a code of conduct for creditors in relation to their duties and obligations under the code. Then the contradictions between the code and the regulation for entity preservation in all circumstances, leading to an absurd proposition of sale as a going concern of a company ordered to be liquidated. And lastly, gross underpreparedness of the stakeholders community for cross-border insolvency, its practice, evolution, an approach to cross-border insolvency, when you see the frame right from the Eredi Committee to the ILC report of 2018. And lastly, about the stressed assets and the new investment avenues that's going to be discussed today. My time is short, so I will try to be brief and just touch upon the points. And if I get the opportunity, I'll participate in some of the sessions and raise the issues that bother me. There was a discussion paper on 27th of August 2021 from the IBBI. And two of the issues which were raised at that time were the code of conduct for the committee of creditors and the restrictions on requests for resolution plans and the use of the Swiss challenge in CIRP. And they did touch upon the question of value maximization versus timely resolution. It's important to read the preamble again, because the point which I'm trying to make will become clear once you read it in context. What does the preamble of the IBC say? An act to consolidate and amend the rules relating to reorganization and insolvency resolution of corporate persons, partnership firms, and individuals, and the words now are important, in a time-bound manner. For what? For maximization of value of assets of such persons, to promote entrepreneurship, availability of credit, and balance the interests of all stakeholders. So the three fundamental issues which we are concerned with in the first theme is time-bound manner is to promote maximization of value. It's not the other way around. Maximization is not the theme of the IBC. In fact, it is conducting and completing the process in a time-bound manner. And this has reference to what the IBBI said in its paper of 27th of August. And it is to balance the interests of all the stakeholders. Now, two questions arise, and it's quite clear from the discussion paper that at the time this discussion was in focus, the continued extensions by the Committee of Creditors and 11 instances which have been highlighted in the paper of 27th August demonstrate the continuous extensions which were being taken and no end to the process of resolution, because the court had taken a line that this is directory and not mandatory, which was not the understanding of the BLRC, but which is a part of the modification because of the way our judicial system works. And as I said, 11 instances under which tribunals had held that there is something clearly wrong in the way creditors are conducting themselves. Instance after instance is given in the report, identifying how there is collusion sometimes between the prior management and the creditors. There is conflict of interest in relation to some of the conduct of the creditors. There are repeated adjournments or repeated second, third, fourth round in relation to the process of resolution, or now recently in the Swiss challenge method also. And one of the things which I have noticed, and which is perhaps not there in the paper, the biggest fallacy of the process is there is no certainty of the terms against which the bid is expected. One of the fundamental principles of law is that price is contextual. You cannot post fact change the terms of the contract and say price was all important. Every price bid is contextual to a term or a contract, and here the contract is the resolution plan. You can't change the resolution plan after the bid is received, and yet this is the doctrinaire approach of the creditors. You can't say in any scheme, and I think even the appellate tribunal is in error, that you can actually neglect statutory regulations and put them aside when they are specifically aimed at curbing the multiple rounds which the creditors have a tendency to do for maximization of value. If the preamble is clearly demonstrating that timely performance is the sequence for maximization of value, it is erroneous to say that notwithstanding IBBI's preparing a legislative text in 39A and 39B, that should be ignored because maximization of value is the right of a creditor. Maximization of value in any code of conduct for creditors can never be in breach of regulations. One of the guidelines which were introduced by the IBBI categorically states that you will abide by the code of conduct. I think it's item Y, if my memory serves me right, in the draft attached to the 27th August guideline. So if you have already put into the public domain the fact that creditors must abide by the code of conduct, and here it is more than the code of conduct, it is a regulation. The code of conduct says that you must abide with the regulations. So it's a double process. There is a code, and the code mentions that you must comply with the regulations. This is the discipline of the law. There can't be an exception to the process, because otherwise what's the meaning of the regulation? If you're just going to change it at will, then why have the regulation? You do it on an informal process, don't have regulations. So that, in my view, is the first theme that I wanted to mention. And there is a plethora of material in relation to how the BLRC thought about time, the fact that the code itself is drafted with clear timelines. And it's just because of our inefficiency in the judicial system that the interpretation that the time is not mandatory but directory, which has emerged. If we had an efficient judicial system, where was the need to say directory and not mandatory? If things could work in a clockwork, I don't think the Supreme Court would have ever come to the interpretation that the timeline prescribed in the statute is irrelevant. If it was irrelevant, why provide for it? So this is one of the issues that I felt is important, and it actually brings in its wake the second aspect of code of conduct of creditors. From August 2021 till now, the code of conduct has been resisted by the financial creditors. And there are complexities in the issue for the reason that all creditors are not subject to the regulation of a single formulation of how they should behave. A private bank versus a nationalized bank doesn't have the same conduct principles, nor is it subject to Article 14 as a public bank would. A public bank's money is public money, whereas in a private bank it is private money. I can decide as a private person what I want to do. But a governmental bank or a nationalized bank or a public sector bank cannot do so. So there are inherent conflicting positions within the group of financial creditors. And the financial creditors are not necessarily those creditors who have security. So even within that category of public and private, there is a further conflict of interest between secured creditors and unsecured creditors. And this was thought about. It's not as if this is a new discovery by me. It is there in the BLRC discussions that if you take the experience of SICA and all prior laws, the financial creditors in that context of the old law was all amorphous, and all creditors were part of a group, as the result of which nothing got decided. So the narrowing of the concept to cover the financial creditors' rights and to restrict the resolution approval to financial creditors was purposive, was deliberate, because this code is evolving as a result of the outputs of the prior law, that what did SICA achieve, what did the DRT achieve. the failures of that law necessitate the preparation of the new code. And that's historically stated in, I'm not talking of anything which is ipse dixit. It is there in the BLRC as specific paragraphs which actually deal with speed is of essence. That is the language used in the BLRC paragraph. There is a particular paragraph which quotes this. The second issue which was decided was delays deteriorate the valuation of a corporate debtor. This is specifically enumerated in the BLRC. The discussion paper of IBBI of 27th of August 21 also clarifies or reiterates this position that the rationale behind putting a timeline to the number of attempts which creditors can cause, financial creditors can cause, is time. Time is of essence, and you must close this process in time, because it's a lot of optimism to proceed on the principle that every time you're going to get a higher and higher bid. Circumstances can change. See what has happened in the story of Adani's. Number 2 in the world, now number 67, overnight. That can happen in a process which is open-ended, in a sense that you don't know what will happen on the next day. And to go on stretching it on the principle of optimism is a wrong logic. Take what a bird in hand is worth 2 in the bush. That principle is very critical in the resolution of debt. It's not about enforcement. Value maximization is a contradictory theory to IBC, because IBC's thrust is resolution. Value maximization is a principle of recovery. And everywhere you're saying that resolution is more important than recovery. Then why the emphasis on value maximization? It's a conundrum. It has to be discussed. It has to be discussed at a high level. And one of the big flaws which I want to highlight is that the IBC is a mechanism which works only in a bull market. In any crisis, and the pandemic has seen that particular crisis, there is a complete drop in the number of people who will bid. Whenever there is an uncertainty, and it could be a recession, your IBC structure cannot happen. For the simple reason that you don't have bidders. And if you don't have bidders, what's the use of this law? So the law is actually not seeing the fact that resolution also happens in a period where there is a crisis. Not a crisis of the company, but a crisis of the economy. Why, for example, did the government and IBBI suspend the law itself by virtue of the amendment which was made, first by ordinance and then by law? Because the pandemic period was so fundamental, where nobody could go to the resolution process. Nobody could approach the creditors because there was a complete ban. It was a lockdown. That's an instance of how impossibility is created by circumstances. It's a situation where there it was a pandemic. Tomorrow it could be a massive recession which hits all across the world. We are lucky that we are still growing, but go outside and see what's happening. Everybody is retrenching. Everybody is going on the theory that business is not going to be as usual. They may have to shut down their processes which are effectively driven on the principle that there will always be a bidder for this business. There is no contemplation of what happens when there is a no bidder except liquidation. Therefore, in my view, this law is incomplete, if not flawed. It has to think of resolution when the markets are not operating as efficiently as it should. The whole thesis and doctrine of the IBC proceeds that the market is the best remedy for distressed assets. That's not a truism across the board. The second, the third theme, as I said, was this whole concept which has been brought in to the liquidation rules, that you can have a dead person being revived. there is a failure to understand that liquidation means death. If you read the scheme and read all the past logic of what is a liquidation order, it clearly enunciates that is civil death. It's like a person dying. If the person is dead, there is no going concern. If there is no going concern in law and for the purpose of the Income Tax Act, this is not a going concern. And so many of the principles like depreciation or for that matter, carry forward losses are all linked to the principle of a going concern. If a liquidation order is passed, there is no going concern. We are not Christ that we can resurrect a dead person. What has been attempted in the liquidation rules is legislature and the regulator are Christs. They can resurrect even a dead person. Can we do that to natural beings? Can we do that to a living person? If we can't do it in a natural state where individuals and human beings are involved, how do you think that a corporate personality is going to override that concept? So this has to go once you're into liquid. And there's another reason which I will give. This concept should not survive because it is giving rise to gaming of the law. A clever bidder will always drive you to failure when he knows he can go back in the liquidation phase and take it at a much cheaper price. Why would he participate honestly in the CIRP if he knows that in liquidation he can get everything, including a going person of a dead entity, and be happier because there is a less value in an asset in liquidation? That's axiomatic. Why would you then, by legislation, create a gaming theory that it is better to go in insolvency, in liquidation, than in the CIRP? This is a serious problem. Please don't underestimate the effect of this, because you are actually telling the world at large, no, please participate by a process of goodwill, but if it fails, don't worry, we'll give it to you in liquidation at a less price. All businessmen are smart and shrewd. They are not wanting to go and pay you more when they can pay you less. So this is an anomaly which must be seriously looked at. I don't think it doesn't show us in good light that we are, in a sense, immature to proceed on the business of how businessmen think. Businessmen will always try and find a less costly process. That's something which you should assume. The gross underpreparedness of stakeholders in cross-border insolvency. There is so much preparatory work and advocacy work which is involved before you bring in the law for cross-border insolvency. Cross-border insolvency is one of the themes. I was fortunate to be a member of the ILC which prepared the first report in 2018. Even I was mistaken in some sense because we didn't see how the world has moved in 24, 25 years, because that report was at a stage where already 23 years of the model code had gone by. And we were approaching the 25th year, which is gone now. In 2020, it would have been 25 years, and there is a lot of commentary in relation to how this law needs to change. And there's a very simple logic. In a single company approach, the presumption is that the foreign asset exists because it's a branch. It's the same legal person which is in two countries, and the principle of where the main interest lies, or the COMI, is going to decide who is going to run that insolvency process. Which procedural head is going to be involved when there are two countries doing insolvency, because obviously the branch has also created its debts, its circumstances of insolvency in a different country. And the persons of that country have a right to sue and a right to recover against the branch. But the branch has no separate legal entity. The branch is actually not a legal person. only the company is the legal person, and therefore, under our jurisdictional law, the duty to file an insolvency is as per the IBC if it's an Indian registered company, and the NCLT, which has jurisdiction, is the place where the registered office is involved. That's clear from our law. Now, what's the way the business is being done? Globally, and even in India, we have multiple joint ventures, multiple subsidiaries, and they're effectively coming out from the holding company or the parent company. And invariably, the failure reasons of a group are because how the money has moved into subsidiaries, how joint ventures have failed, and the story is not in the main company. The insolvency issues and the cause of insolvency lies in the underlying company. And that's quite evident if you take your history of Videocon as an example. It's the downside, it's a 1 tier less or 1 tier companies which completely destroyed the enterprise, and obsolescence which destroyed that enterprise. So to today have a law that we will only tackle branches will, in my submission and most humbly, look foolish. Because in the context of cross-border insolvency, with the GIN convention that is there, every country, and Singapore at the topmost, is going to say, look, India's laws are not progressive. Come to Singapore and we will resolve this across the globe. That is their marketing slogan. That is the reason why the SAIC, the Arbitration Center, has succeeded. That is what they actively promote and say when you look at the SICC that they have set up. They have set up an international court for commercial disputes. By virtue of setting up an international commercial court, they have taken upon themselves the jurisdiction of the world, not only Singapore. They are able to say, here is my solution cross-border. Come to me. I have got the best judges who are experienced judges and who are not Singapore judges. They are judges across the world with expertise in resolution, expertise in insolvency, and that is unparalleled. Now, we can't have that in an Indian context. Can we import a foreign judge and say, sir, please sit on my tribunal and give me the benefit of your experience? No. So when you're in the space of unfair competition between what we can structure in India and what they have structured, we need to be far more progressive and actually put in the issues that we need and consider are important. World is looking to India because you have the biggest population, you have the biggest market, and probably therefore you have the biggest insolvencies. Now, do you want to give away this jurisdiction to a Singapore or a Hong Kong or Japan or London or, for that matter, New York? Because all these jurisdictions have very efficient cross-border experience, more than 25 years of it. And you are the fledgling in this space. For being a fledgling, you need to be far better prepared. You must analyze the weaknesses of their system. You have to see that those weaknesses don't come forth in your act and your regulations. You must be forward-looking, consistent with the principles of the Constitution, that you don't have extraterritorial jurisdiction. Even in relation to Section 18 of the IBC, which effectively asks the interim resolution professional to collect and gather and control even foreign assets, there is a severe doubt that do you have extraterritorial jurisdiction? And can you do this on your own without participation of a foreign court and a foreign whole authority backing you? Can a resolution professional go to an international country and say, no, these assets are mine, give it to me, just because of Section 18? Severely contested. Now, if these are going to be the principles, can your participation in the UNCITRAL Convention of Branch Insolvency, and I'm introducing a word to that. Is it going to solve your issue of cross-border insolvency? The world has moved by in 25 years. Today, ask yourself, ask any practitioner, how many companies prefer to have a branch? And the problem of taxation in relation to a branch. And your answer will be resounding no. Nobody wants to have a branch. Everybody wants to have a subsidiary or a company because they can plead this is an independent agent and therefore taxable only in that country, and global income is not subject to tax in India. So there are very good commercial reasons why we need to look at our law competitively. And we should look very proactively, even if the law on group insolvency is not in our IBC. We should rapidly move to introducing the concept of group insolvency, and there is a UNCITRAL model law on group insolvency. This is something which can be very quickly turned around for you by the ILC or by any special committee that you set up. Why wait? So this was, and preparation is important. I'll tell you why. It is quite clear from the Jet case and the Videocon case that a convention, or in a sense the guiding principles and protocol, is necessary in every case. Are we going to have as many protocols as there are tribunals? Do you trust the wisdom of the tribunal to prepare a convention or prepare a guideline or a basic principles across the board in India with uniformity? My answer is a flat no. It will not happen. And therefore, I contest what has been stated in the cross-border making of the rules under the KP Krishnan committee, that every tribunal should have the jurisdiction to conduct cross-border insolvency. This has to be phased. There has to be first a confidence-building measure between Indian tribunals, Indian appellate authorities, and the countries where most of your companies are. In the absence of complete, compatibility, why is the GIN guideline so applicable? Because 5 countries have agreed. Do you have an agreement even one country? No. How do you expect cross-border insolvency to be effective when you have not even made an attempt of creating a collaboration with countries which you trade the most? Take the principle of material is obviously available as to where have Indian companies gone, which is the maximum place where the business of Indians is happening. Set up at least a collaboration with those countries and come to a convention that if in cross-border insolvency arises, how will we deal with it as the basis of dealing with cross-border insolvency? Your domestic rules, your domestic regulations will not be the guideline or test on the basis of which cross-border insolvency will happen. That's exactly why there is a principle of choosing one court or the other, or choosing one tribunal or the other, because the principal place of business, the main interest, is where the law is sought to be applied. And if that's the case, you need to have the law settled. For example, the question of whether Chinese law will be agreeable to an Indian tribunal. I don't think so. Even under the CPC, if you look at it, on the question of reciprocity and notification, there are hardly, except for the Commonwealth countries, and which is a very old reciprocity principle, there are no treaties which really enable you to have reciprocity in execution of judgments. These principles are principles in relation to status and therefore matters in rem. They are not judgments in personam. And there is a clear distinction in law as to what are matters in personam and what are matters in rem. You are dealing with status of companies, and just the recent judgment of Justice Chandrachud reiterates that proposition. Don't declare a person a defaulter till you give him a right to be heard. Why? Because you're recognizing that you're killing somebody through the process of law. And if you are doing that, it is your duty to have principles of how the lending community will be dealt with. One of the consequences which the tribunal just fails to recognize, and I think even all of us have not really emphasized, is that there is a cost to delay. The longer the time taken, the greater the discount which is offered by any investor. And that's an axiom which even the BLRC accepts, that delay means deterioration and therefore less price. And therefore one has to identify all factors of delay, including, as Siddharth mentioned in the pre-meeting that we had, is about managing the services. The resolution professional is inadequate to deal with all the kind of issues that are embedded in his duties. Can he draw up a prospectus? Can he draw up an offering circular? Does he have the wherewithal of an underwriter? Is there a continuing memorandum of the state of facts of a company? You write incomplete facts, you will straight away get a discount in the bid. You cannot expect a fair price when you have not written complete facts, because the bidder will totally discount your value because he is worried that something which you have not written will pop up, and which is happening. Why are resolution plans getting stuck? Why does the regulator in relation to licenses throw a curveball? Why do tax authorities and the government, though they are relegated to the level of an operational creditor, stand up and say, no, my rights are important, you can't destroy them. I am not an operational creditor, I am a statutory creditor, and therefore give me the rank first. Which is precisely what BLRC said should not happen. The preamble says it. Alteration in the order of priority of payment of government dues. It's recognized in the preamble, and yet our Supreme Court says, no. They are a statutory creditor, and therefore they must get benefits of being in the rank of financial creditor. Completely wrong. And we must be active about these things. We must tell the courts that this is going to destroy our market. And that leads to me the last topic I want to talk about. Why are stressed assets not having a market in India? And there are many reasons. Firstly, the litigation uncertainty. Everything is litigated till the cow comes home. And there is no end to litigation, whether it's an interim application, whether it's a final resolution, whether it's a government action, whether it's an operational creditor, whether it's a home buyer. There are myriads of issues which keep propping up, and there's no finality despite the law saying it is final. Clearly, Section 32 says that, or 31 and 32 says it's final, it's binding. Despite that situation that it is final and binding, if the courts are going to entertain forever rights, because judicial review is a fundamental right and a basic structure issue, then why would an investment market arise? Where is the certainty of the product you're selling? That's one of the main reasons why the stressed asset market is not. Secondly, the main issue in relation to stressed assets is there is no certainty of information also. You have not been able, and it's impossible for a resolution professional to have the standards of a prospectus. Every offer for sale is like a prospectus. Can you realistically expect a resolution professional who has hundreds of duties, not one, including managing the company, to really write you a prospectus like offering circular? And you have to take the principle that the less information means less price. And you need money from external sources, foreign bidders, to take your assets, because this kind of money does not exist in India. If you cumulate the extent of financial loss, including just those of the banks, your fundamental question to ask is, where is that money to fill that gap? It's not in India. So the premise that you can find and plug that hole from Indian money is absolutely axiomatic. And if you have to approach international markets to have a principle of either assets being sold in a sense of a REIT-like structure, or for that matter, a representative interest asset, an asset regulation, asset company, AMC, effectively selling its units with underlying assets or underlying debt, that requires certainty of information, that requires valuation, that requires process, not when you have to do it continuously. In the market determines it continuously. When a share is actually, or any security is on a stock exchange, there is a continuous valuation which is not done by a regulator, which is not done by the stock exchange, which is not done by SEBI, but it's the market, the buyer and seller who determine the price. You have to have that possibility in relation to stressed assets. And the history shows it. In the first 2 years of the IBC, a lot of marketing was done by the former chairman, by people like CII, FICCI. Everybody went out, including me, and pitched for this market to become vibrant. In the initial stages, there was interest, but it's gone. Ask any international banker today, will he create a security instrument in relation to stress? Answer, you will get a resounding no. Because he says, just not worth my time. I get so much embroiled in litigation and uncertainties of valuation. I don't know whether I can create a market which is global. Am I restricted to only Indian trading? A host of issues. So when you say you want to create a vibrant, secured, stressed assets market, you have so much non-legislative things to do. These are not matters which you can plug by a rule or regulation. These are effectively outside the regulation and are circumstances which you need to create so that you have a fair market, so that you have a vibrant market, and so that you have foreigners participating in your market, which has happened in the debt market and which has happened in the equity market. So one needs to really evaluate all these when you're examining the success of IBC. It's not the number of cases, it's not the number of resolution. That clearly is an indicator of success, but that's not the only success. And you need to look at the question of what happens when there's a bear market or when there is no market. You can't say that the law is suspended. That is a complete defeatism principle. If you see what happened in Singapore or you see what happened in UK, they made a law to deal with insolvency in the context of pandemic. They just didn't say that, oh, I shut my windows. So we need to really look at all these things, and these are critical continuing issues. These are not casual issues. COVID is back. Are you going to just suspend the law again? It's a serious pandemic-like structure today. So we get all these issues occurring again and again, and we need to think now more as a nation. Are we going to be the subject matter of derision or ridicule, or are we going to be counted in the top tier of global economies, which we are aspiring for? We want to be number 4, we want to be number 2, number 3 in the global economy. But are we doing what those countries have done in the last 2 decades? And we need to examine that structurally. We need to examine as to why they have been successful and why we are not. That's all I had to say. Thank you so much. Yeah, I think the next speaker is Dr. Ashok Haldia. He is a very learned person, and I'm sure you will enjoy his presentation today. Thank you.
Thank you very much, Honorable Chairman Shri Ravi Mittal, the Chairman IBBI, Shri Sadul Sharaf, Mr. Iyer, Mr. Nigam, and Mr. Vikas Mohan. Oh, I had some spray in my leg, so I thought.
Near your mouth, please.
Yeah, okay, thank you. As a Indian Institute of Insolvency Professionals of ICI, we are indeed have a great pleasure in cooperating and collaborating with CII in participating in this conference. We have been collaborating through a number of programs, through discussions, brainstorming, thought-provoking at the platform with the CII on number of occasions. After Mr. Sadul Sharaf, I don't think I have many more things to speak. I would just highlight few thoughts, and particularly in the context of the insolvency professional. I see a large number of insolvency professionals present here. I remember I was part of the Indian delegation to UK to study their IBC system way back in early 2000. It has taken almost 16 years for the IBC to come in place. A lot of discussions, debates, reservations, limitations, and when it was pushed by the NPAs striking the Indian economy and the financial sector, the IBC came into being within the ecosystem prevalent at that point of time. So we need to keep that context in the mind, that it has evolved and it has been constantly evolved. It has got matured, but matured only under the circumstances it was set out to start with in the 2016. If you look at the structure of IBC, it clearly said that there are certain critical aspects that would be addressed as we get maturity in understanding and implementation of the IBC. Time has come to address those issues. IBC or IBBI, I would say, has been, and I've shared on the public platform with or without the presence of the IBBI officials, that it has been one of the most proactive, open to dialogue, interaction, and very fast and innovative in responding to the changing needs. I remember the chairman of IBBI and the president NCLT agreeing to have an open house discussions with the insolvency professionals all across the countries. They were mere listeners. And when I was talking to him just now, as per his suggestions of the problems that the insolvency professionals are facing, in the process, in the institutional structure, the law and the regulation of the IBC, he said, you send me this, what are your questions? We would clarify, we would rationalize. We did collect more than 80 such questions and send it to IBBI. And the chairman just informed me that within a week he would be responding to us as to what the IBBI has done on that. Normally, I have been in one or other capacity a regulator in limited sense, maybe even now. But the regulator often refrained in talking open and talking clearly, at least on the public platform. So that's a great thing. And I'm sure that's the spirit that is continuing. As I said, we have achieved a lot for what we have set out to be. There is much more needs to be done. There are many pain areas. And the pain areas, as Mr. Saraf said, is the time that is taken by the CIRP. The approach of the stakeholders the understanding of the stakeholders, and also the interface among us and between the various stakeholders, including with the NCLT. Now, these are the aspects which the law has to address, which has to be addressed by the stakeholders coming together, change their attitude, approach, and behavior. And I would accept that the insolvency professionals are equally part of that process. They have a primary responsibility. The insolvency professionals are one of the pillars of the IBC. The success, and often said, and the failure to a large extent at the ground level of the IBC depends on the insolvency professionals, how they understand, act, behave, respond, and interface. And it's much more than art, science. It's possibly far more than art, and they have to be made apt to that. There was no profession of insolvency professionals since in 2016. And everyone wondered, can IBC take off in the absence of a professionals? Look where the IPs are today. They have evolved, they have developed, and much more needs to be done. The mechanism of the IPE has come, and I'm sure this would lead consolidation of the IPs, the insolvency professional firms, and many other players have already started coming into the insolvency areas. There are certain areas I will highlight. Of course, Mr. Saraf has pointed out to those. But one thing that we always need to keep the economy, the political and social system that we are working in. We need to accept its limitation. If we are not able to understand its limitations, maybe right limitations, maybe wrong, maybe rational, possibly will not be able to achieve. If we want to transform, we need to be patient. We need to be critical. We need to be constantly aiming at as to what we want to achieve. And that's what possibly the time has come. 6 years, a lot of deliberation, discussion have taken place. And I'm sure these would continue, Honorable Chairman, in my view, for another 2-3 years before we reach to the next phase. So time has come for IBC version 2. And government and the IBBI is already working in a number of ways: procedural reforms, legal reforms, rules, regulations, empowering insolvency professionals, rationalizing the problems and challenges that they are facing, and so on and so forth. But I believe the areas which needs attention is possibly the institutional structure, the streamlining the systems and the processes. Can the existing systems and processes be streamlined? Mr. Sadul Staff rightly said COC. It's an important player. Now, we cannot shirk away our responsibility by saying that the banks and the COC is not our responsibility. It may not be my responsibility, but it is our responsibility. And therefore, they are a very important part. The interface of the stakeholders, be that the professional, legal, IPs, or valuation, anybody with the NCLT and intersay, if that interface with the adjudicating authority and judicial authority is not streamlined, possibly we will not be able to achieve what we intend to. I believe the judicial authorities have been able to appreciate and possibly are changing with the times. You look at their approach and decisions pre-2016 and now, there is a shift. But a directional shift, a total diagonal shift would possibly take time, and that's a constant endeavor we have to. Can we find out some way of interacting in a transparent and fair manner with the judicial authorities? That would be one. That would be, I think, one thing. Another thing is the technology infusion. Can the technology end-to-end, from the beginning of the CIRP to the end of the process and the liquidation and the completion thereof, can anything and everything that can be automated or work through the technology must be done through technology. And that should be and I believe out of my experience that we can achieve 50 to 60% efficiency in the current mechanism. Time is essence. But I would also say in the system that we are living in, the value also matters. But if we address the time, the value would automatically be there. The another important part is where are the investors, where are the financing products? We have been talking about the corporate debt markets for decades and decades. Where is the corporate debt market? And they're talking about the junk bond market, which is necessary for revival of the sick companies or stressed companies, is virtually non-existent. There is interest of investors in investing into stressed assets. Maybe they are available at, I would not use the throwaway prices, but maybe the less than the price they would normally require to invest to bring out that capacity. Where are the institutions? Where are the financing structure? Where are the financing products to finance these? This is the another areas. You cannot blame IBC if you do not create an ecosystem that supports the IBC. Understanding, I would believe the system we are living in, there would be constant criticism or the value maximization or optimization. We'll have to live with it. But the constant effort to rationalize and simplify the structure and processes would possibly, to me, would increase the value maximization. We need to have a bond market. We need to we need to change the orientation of the banks and financial institutions towards stress assets. We need to empower them to take the decisions so that if they take a wrong decisions, they do not have a fear psychosis. There is a large, I would say, fear psychosis in all the stakeholders. What if we do? That fear psychosis, what if we do, what if we will not do, that prevalents in the insolvency professional, that prevalents in the valuation professionals, and I can't say about the legal profession, but then about the banks and the financial institution. I think that if can come only through the fair and transparent processes, bringing infusion of technology into the process. And the another thing that I would say is that the pending areas which we thought we would address as the law matured, the group insolvency, the cross-border insolvencies, we address the sickness at the ICU stage. Why? We should address the sickness at the incipient stage. If I am a promoter, I do not know how to set up a project and I conceive a wrong idea, select a wrong land, wrong plant and machinery, leave aside my intentions, maybe with bona fide intentions, I am giving birth to a stressed project. Now, how to address with that? And we are working, trying to build capacity of the insolvency professionals for end-to-end services. The CIRP to me should be the last resort. Before that, all other measures should be explored. Mediation, out-of-court settlement, pragmatic, I would emphasize, pragmatic approach to the reforms and restructuring. Participation of all these stakeholders. That is possibly, and if that fails, then the CIRP, I believe the IBBI approach these days is towards that end only. And if this fails, then yes, CIRP within time-bound manner and the liquidation within a time-bound manner, what may come. If the things do not move, if somebody doesn't respond within a time period, things move forward. But then that's easier said and done within the judicial system, and also the need for being transparent, fair, and also the principles of natural justice we need to follow. So these are, I thought, and we, knowing that version 2 IBC is in the offing in the near future, we at the board of IIPI have set up a committee of the board to vision as to what would be there in the IBC 2, version 2, and how we need to prepare the insolvency professionals to face those challenges. What measures the IIPI needs to take to be able to cope as an institution, as a front-line regulator to cope with that situations. We have been interacting with the IBBI, with the insolvency professionals, with the corporates, with the legal professionals on a very regular basis. We have structured, we have identified the gaps. Mr. Shadul Sharaf highlighted gaps. Admittedly, there were gaps, as I said, there was no profession as such. We have identified those gaps, and we have organized a number of programs, including the executive development programs for 6 days, addressing those specific needs, bringing the rating agencies, banks, financial institutions, the valuation professionals, so engineering organizations, the corporate debtors, the investors, so on and so forth on the same platform. We have been interacting with the IBBI, and the IBBI and IBBI has given us a number of ideas and guidance. We are currently working on that. Some of the thoughts the chairman IBBI gave to us recently, we are working on that, and I'm sure the final outcome of that would lead to better, vast improvement in some of the areas. So with that, I wish all the sectors, I know there are luminaries in the panel discussion, and the entire team of the Triple IPI, I believe, is present here. We are here to note that, and we will certainly, as a proactive organizations, we would work towards this. And I believe as a regulator, we have far more role, frontline regulator under the aegis of IBA, we have far more role, onerous responsibility to develop an onerous professions. We know an insolvency professional, if he does 9 things good, but he does not do 10th thing right, he may be under attack by all the stakeholders. That's the risk that profession bears, and he has to continue with that. It has to respond in a more onerous and responsible
May I
manner.
request that we...
Okay.
I just wanted to mention both me and Mr. Haldia in some sense have got carried away and have spoken well beyond our time limits, and as a consequence, we are awaiting Mr. Mittal's speech as a chairman of the regulatory body. And my request, Vijay, though I think it's unfair, is to request both of you to try and crunch it as much as possible so that we give full time to Mr. Mittal.
No, please.
No, I think finish in sequence.
I'll speak very informally. I don't.
Yeah. So request Vijay, just keep it as short as you can.
Sure.
I am guilty for having exceeded my time.
One can't say no to Mr. Shroff. No, definitely not, sir. Respected Mr. Mittal, Chairman of IBBI. Respected Mr. Haldia, Chairman of Triple IPI. Respected Mr. Shroff, Mr. Nigam, and my fellow colleagues on the panel. Respected seniors in the audience. My fellow insolvency professionals, ladies and gentlemen. I am cautious and conscious that I do have the regulators on the panel with me, but I draw confidence from the various insolvency professionals in the audience. And therefore, I do dare to suggest to be a little bold in my comments, setting up the context for this conference, which has been very commendably organized by the CII today. Evolving paradigm, looking ahead rather than looking at the past. To my mind, I would like to use the principle of optimism, though Mr. Shroff said we must use it with a degree of caution. I do believe that the law is fine. And for the reason, I use 3 reasons for that. The first is that the objectives are very clearly well defined. Mr. Shroff mentioned them in the morning as well. Value maximization, a viable and feasible and sustainable resolution within a time-bound program for the benefit of all stakeholders. Very clear, enabling all stakeholders to work towards that common purpose. Second, the framework is very sound and clearly very adoptable, very usable. Be it the framework and process for the claims verification, or be it the process for even the resolution plan. True, there is some tinkering required, but that's part of the process to my mind. And the third, Mr. Haldia mentioned this as well. One of the reasons why this code has worked is because it has stayed relevant for the needs of the market. And of course, we all must commend the IBBI for enabling focused interactions. They followed a very clear approach, looking at specific stakeholders for specific issues, seeking comments, and then immediately implementing the tweaking which is required to ensure that the code is relevant. And reasons, therefore, my ladies and gentlemen, I do believe that the code is fine. That's the basis for today's discussion. And if I look at outcomes, there are 3 points I'd like to make in terms of what have we achieved. First, of course, clearly has been the very successful resolutions. Let us not look at the one black dot in a white sheet of paper. Yes, there are some which have not worked out, but there have been very clear, solid, strong resolutions. If you look at even the top 12 accounts, be it Bhushan Steel, SR projects, and many others, there have been a successful resolution. There have been further investment which has been made, and there has been wealth creation thereafter in terms of assets which were locked up quite badly. There have been innovative solutions which have been created by all stakeholders in ensuring a resolution which has remained viable and sustainable. That is something which all of us must commend ourselves to achieve so far. But there are 2 other elements which has been, shall I say, very strong benefits from implementation of this code. First is the behavior between creditors and borrowers. There has been far better discipline between both creditors and borrowers. And what we learned recently, this phrase which I just pick up, the irrational reluctance. I picked this up at the IM conference in Bangalore. The irrational reluctance of creditors to lend, a lot of that are dissipated because of the code being what it is today. There is the fear of the law in the borrowers as well, and therefore there is better compliance. But the second dimension of behavior which I would like to suggest to this audience is that there is better behavior in our authorities today. You see tax authorities, they're far quicker in sending out their notices, far more disciplined in filing their claims, so as to ensure that they wish to show that they have expended all their benefits and all their rights under their statute before coming to IBC. And if you look at it, the recent judgment the Supreme Court gave us in terms of identifying the employee benefits in terms of Provident Fund and gratuity dues to be much higher than any of the waterfall mechanism, there's going to be a clear focus on such authorities. And there are people going to ask them, have you expended all your rights under those laws before coming to IBC? Have you ensured that you have issued notices under the Provident Fund Act, ensuring that the corporate debtor has paid whatever he has to pay? And all that has failed, and therefore you're requiring your support from this law. And that automatically will, I'm sure, enhance the behavior and better governance in our economy. So this is clearly the benefits that we have achieved from the code, ladies and gentlemen. And the third dimension, apart from the law being right and achieving these outcomes, is that there has been a strong expansion of the market. Now we see more solutions, more players coming in. We have the special situations funds. We have ARCs who are getting more active. We have the NARCL. Yes, there is foreign interest which continues. People are still positive about our country. And there is a degree of digitization which has commenced of all our various analog records. And I therefore do believe that we are on the right step. The evolving paradigm is on a strong footing. Then comes to the next point. What is therefore the way forward? First, the first dimension, yes, the process integrity. There is a clear session after this one talking about enhancing the process efficiencies and effectiveness. Yes, that is a continuous process. I do believe that this journey of digitization would lead to digitalization and then digital transformation. And digital transformation will hopefully achieve the sharing of information across various authorities, across the platform, across various stakeholders, enabling early warning signs, enabling red alerts which are auto from the system itself, so that the patient is brought to IBC far before and is not dead on arrival as we see in many cases today. That is the hope in terms of building up the professional efficiencies. I'll cut short. The second item, which is close to my heart, is value maximization. I know Mr. Shroff did guide us and caution us of ensuring that this is within the time-bound process. But again, I commend all stakeholders that we have actually worked the code very well. people who are working on the M&A side of things, who are look at process advisors, who are on the buy side within the IBC ecosystem. We have seen deal nuances getting better, more sophisticated. We are seeing more solutions, more creative solutions. And this definitely is on the right path. But there is the debate of process integrity and the value maximization. And this is going to be something which we're going to discuss in the sessions ahead. What I'd like to suggest to the audience is something we need to definitely think about, is that we can't hard code a process because every corporate data is complex. There is a degree of flexibility required. And why? Because the objective must be there has to be significant competition introduced in the entire resolution plan process. There has to be active engagement with potential resolution applicants. We must try and encourage more and more to come and participate in the process. We have to encourage and create that platform where more resolution plans could actually be presented to enable the COC to then achieve that maximization of value. And that point, therefore, requires a degree of debate of how to achieve this within this time-bound manner and within the protocols of the code. The next item is something which is close to my heart, is on the role of the RP. The role of the RP has been maligned quite a bit over the last few years. And I must admit that some of it is clearly correct. There has been severe indiscretions which has happened. And I do commend again the regulators, both the IBBI and the IIII and the IPAs, who have then ensured that they've used their disciplinary mechanism to weed out such indiscretions. That was necessary. But let us not forget that at the end of the day, we RPs, as I think Mr. Haldia said, or Mr. Shroff said, we are required to do 100 things, not just one. And even the 100 things, if you get one thing wrong, then you're hauled up. Yes, so be it. But that's the nature of the job, and we have taken upon ourselves. But therefore, all of us as stakeholders, need to remind ourselves that yes, the RP after all is one individual. He may be brilliant, and I do see that the seniors here are masters, but he does require help in sorting out various issues. The RP fee, the related RP fee, all that has been now clearly sorted out. But the other element which has to be discussed and which requires further investigation, debate between all of us, is the entire gamut of CRP costs. There are costs which are unfortunately still required to be incurred, which one needs to see, can we get bolder, can we be a little more innovative and tackle such costs? For example, rent for property which are never used, or payments to labor and incidental, which in today's environment, as Mr. Haldia said, we have to be sensitive to the political and social environment in which our country operates. It's not easy to terminate employment. So there are certain costs that you would continue to incur, and those costs, operating costs sometimes, are far higher and far more onerous. The RPs, and I say myself, earlier on we used to look at the code and say, is this prevented or is this prohibited? And if it is not, we should be bold enough to do it. Mr. Haldia used the word that there's a fear psychosis. I don't think it's gone to that extent. But there is a degree of diffidence, I must say, amongst all of us. Now the question is this provided for in the code? If it's not provided for, let us go to the COC or let us go to the NCLT and seek permission. And perhaps we RPs are also guilty of blocking some of the time of the NCLTs with these applications. But that's because of this degree of diffidence. So my request, ladies and gentlemen, is to once again embolden the RP, be supportive so that all of us together can then be bold and innovative. Because in this space of restructuring and stress resolution, you can't have precedented solutions. Each situation is an unprecedented situation. And finally, ladies and gentlemen, the point I'd like to make that we are, as Mr. Haldia said, at IBC version 2. We are at the crossroads. If we are at the crossroad, it requires all of us stakeholders who are benefiting from this ecosystem can no longer be passive bystanders. The question we need to put to each of us is, if we are not part of the solution, then are we not part of the problem? And therefore, all of us must put to ourselves that we must be creative, must be innovative, must be consultative and transparent and collaborative amongst all of us together and achieve what we are sought to achieve. And what is fundamental principle, as I keep repeatedly saying, amongst all relationships, right? The fundamental theme is mutual benefit, joint responsibility, shared destiny. And I do believe that this philosophy, we all of us must again take to our hearts and ensure that we continue to have success under this code. Thank you, ladies and gentlemen.
I would now request Mr. Siddharth Nigam to give his address. And again, Siddharth, please keep it as tight as you can. I'm sorry for myself having exceeded the time limit, but we owe it to Mr. Mittal to give him adequate time.
Thank you, Mr. Shroff. Good morning, ladies and gentlemen. Good morning, Mr. Chairman, Mr. Mittal, my fellow panelists, Mr. Shroff, Mr. Mohan, Mr. Iyer, and Mr. Haldia. It's indeed an honor and a privilege for me to be part of such an esteemed panel. While a lot's been said, and I'll try not to repeat that and keep it short, what I wanted to share was more a perspective, an optimistic perspective as a transaction specialist. I think at the center of the IBC is to enhance the ease of doing business. And I think it is something the law or the code has done very well. It addresses corporate persons, partnership firms, and individuals. It has been a pioneering law in terms of bringing multiple parts of multiple stakeholders together to try and find an effective solution. Sometimes I think we are a bit harsh on the imperfections or the inefficiencies. I think we need to look at, how this has enabled a paradigm shift in all the erstwhile insolvency regimes in India, and we've had many in the last 4 or 5 decades. While at the heart of it is to maximize value realization, but it is also has to address the interests of other stakeholders, whether it's employees, whether it's sectors, whether it is government, so on and so forth. I think the law itself, it aims at developing a robust stressed assets market and providing what I would call an efficient exit to genuine business failures. I think with that at the center, let's just look at what has the law or the code led to. In the year FY 1920 or financial year 20, the resolutions or the amounts that we got back as part of IBC are 46% of claims. I think that's a phenomenal achievement. Even in the following year, the recoveries were not that high, but they were still about 20%. It has been the highest getting value out from situations. Also, another data point, and there is a lot of data already published, but about 51% of the 6,000 odd filings under CIRP have been found some sort of solution. I think that is, again, we must all pat ourselves on the back as a country, as people involved in this area, that this has been very effective. I think in the years between 2016 and 2023, and especially in the first 3-4 years, the press also gave adequate attention to this pioneering, legislation, this pioneering change or reform agenda, and it made to the headlines, which in turn has led to the entire ecosystem coming together. I think all of us got together very quickly, whether it's on the RP side, it's on the the legal side, engaging with the government, engaging with the stakeholders. There have been multiple changes to the law, and I think I must congratulate IBBI on their proactiveness, on luminaries, a lot of them in the room, Mr. Shroff, Mr. Vakil, who have taken the lead in engaging with policyholders to continuously give feedback, and whether it's 29A, 12A, including homeowners as stakeholders within the whole waterfall, and continuously making that change, taking that feedback, trying to bring about a change. I know we're at the point where IBC2 is something that we need, but I think the shift between what the original law was and what it is today is a big change that has happened. There are areas, I think fellow panelists talked about group insolvency, about corporate cross-border insolvency. I think those are areas that certainly need a much better look in, a much deeper look in. Having said that, I think another area which will certainly make the regime a lot more vibrant is an ability to pull in global capital. As a transaction specialist, sometimes it's frustrating when you see hundreds of billions of dollars of distressed capital available with global investors, and not even a fraction, a drop in the ocean has actually made it to India. And it is not because of lack of interest, I can assure you. I have sat in a room where almost $3 trillion of capital, US capital, came to listen to what is happening in the insolvency regime. One of the things that will help us take this forward is the last few years has seen big cases, a lot of strategic interest. As the size of the companies becomes smaller, the sectors are more on the fringe, we will require to rethink how to resolve that. And I think that's where financial investors play a major part in that. There was a conversation around pre-packs. There is already a mechanism of pre-packs for MSMEs. I think that needs to get expanded. There are genuine business failures. Not every insolvency is because of lack of governance or fraud. These are businesses which need to be revived. And I think at the center of it, while value maximization is something that we talk about a lot, it is also about making companies go on, survive, because beyond the promoter, beyond the creditor, there are other stakeholders. There are employees, there are vendors, there are customers who also rely on these companies. And I think their survival, to make our economy more vibrant, I think we need to rethink how do we look at mechanisms such as pre-packs to apply to a larger audience. I think also, again, it's been talked about the lack of timeliness, or the stretch of times of resolution does keep foreign investors away. Interest rates went up in the US, the capital got diverted to the US economy. This is global capital. So we as a country have to compete for this capital. And I think that goes back to what are the changes we can specifically make to attract this global capital. I think the other piece I'd like to just quickly talk about is creation of management capacity. Once you take the promoter out of the mix of a company who runs the business post-insolvency, I think there is certainly room to groom independent management capacity to run these businesses. And I think finally, what is life post-insolvency? When our pre-discussion, we did talk about personal guarantees and enforcement of the same. Again, capacity needs to be built to enable recovery post-insolvency. Now, whether you do it through enforcement of guarantees or asset recovery, for my organization, for example, in the UK, we have a very robust asset recovery practice, and a lot of creditors, while they will push through the insolvency quickly, they actually a large part or a substantial recovery they make post-insolvency. So that is another element, for us to think about as stakeholders. Just keeping it short and simple. That's all. Thank you, and I look forward to the rest of the day here. Thank you.
Thank you so much, Siddharth, for being so crisp. I would now request Mr. Mittal to give his address, for which all of us are most eagerly waiting.
So, good afternoon, friends, dignitaries on the stage and dignitaries in the hall. I know, I think 30, 40, 50% of you, and I find that almost the whole knowledge in IBC is today sitting in this hall. And it is very difficult to talk to this kind of a knowledgeable audience. Mr. Shroff, while introducing the subject, talked about delays and several other topics that he felt were important for the IBC. Now, in the last 6.5 years, IBC has done about 650 resolutions, as you all know. About 2.7 lakh crores of resolution has been done. But more important than that is that IBC has led to settlement of cases without resolution or without admission or with withdrawals. Now, about 7 lakh crores cases worth about 7 lakh crores have been settled outside the resolution process under IBC, and these are cases where the creditors have withdrawn. So what does this mean? There is a perceptible change in the creditor-debtor relationship, and this change in this relationship has led to this kind of a behavior. Now, I consider this a very important change. When I talk to bankers, and I talk quite a bit to bankers, they tell me that there is a perceptible shift in the behavior of the borrowers. I remember, first time I joined DFS, I was then nominated to the Punjab National Bank Board. The first time I went to the board meeting, and before the board meeting, I went to the MD's room. A borrower was sitting and he was telling the MD that my account has become NPA, so now it is your problem. These kind of things will not happen now after IBC, or these kind of things have stopped happening after IBC, and that is perhaps the biggest change that IBC has brought about. But then IBC also has problems. As Shardul ji was pointing out, there are problems relating to delays. There are problems relating to haircuts. There are other problems. Now, we have done some analysis about this in our office. We find that we say that IBC is for resolutions, but we evaluate IBC based on performance or based on haircuts or based on what money the creditors get. So everyone says, IBC, the return under IBC is 32%. So the rest is the haircut that the creditors are getting. But IBC was basically meant for resolution. And we forget or we do not know what has happened as a part of resolution. This 600 or 650 companies that have been resolved, what has happened to their sales? What has happened to their turnover? What has happened? What is their contribution to GDP? How much more taxes have they paid? Whether employment has increased because of these resolutions. So we have given this study to IIM Ahmedabad to find this out, whether this resolution has led to a change in the economy. And this study, that the report should come out in the next 2 months. I have seen the preliminary figures that they have collected, and I find that sales have increased or turnover has increased manifold after resolution. EBITDA has increased manifold. Profit after tax has increased manifold. Market cap has increased manifold. And these things have not been documented. And really speaking, these things are therefore not in public domain. So I hope that in the next 2 months, once this report comes out, we will have a better understanding of what IBC has achieved in terms of resolution. The other point I want to talk about is what Shardul ji was talking is delays. Now, there are delays at every stage. There is delay in filing of the case before NCLT. There is delay in admission. There is delay in resolution. Once resolution happens, there is a delay in approval of the resolution plan. There is delay at every stages. Now, you are really the people who implement IBC, and you are the cream of IBC. We have found that in several cases, and at least in cases which have gone into liquidation, valuation has been done at 2 times. Once during CRP stage, another during liquidation stage. In several cases, not in all cases, but in several cases. When we compared this liquidation value, which was done at 2 stages, on a time basis, we found that there is a decrease in value by 1.8% per month. What does this mean? This means that if we take more time in resolution or more time in liquidation, the value of the asset declines. All of us know that the value of the asset declines. This is not a new thing, but the figures available in my office show that the value declines by 1.8% per month, which is quite a substantial decline in value. We all know that when something becomes stressed, the value starts declining at a faster pace. And again our data shows that it takes more than a year for the creditors to file cases in the NCLT after a default happens. Now, as Mr. Nigam was saying, that in some countries, more recovery is done after the case is brought under insolvency. Therefore, I have been telling the creditors that on default, please bring the case to NCLT or please bring the case into the IBC system. And you can still withdraw it if there is an agreement or if there is a resolution outside the system. This will reduce the delay and improve the recovery to the creditors. Now, there's another thing connected with this, which I want to say, because this is a CII conference, and I hope that some promoters or some entrepreneurs or at least their advisors are present here. My experience, I have worked in the industry sector for few years as a junior officer, and my experience shows that the industrialist knows when his company is going bad. He decides as to whether to put in more money or whether to revive his industry or to let it go downwards. Now, why don't the promoters take initiative? Why don't the promoters take initiative in coming under Section 10 of IBC? Now, when I tell them this point, they say, that the company will go out of my hand under IBC. But when creditors come under IBC, even then the companies go out of your hand. Now, what is the advantage of coming early? If you come early and if the moratorium starts, at least your debt stops. Your total debt will then stop at that moment. And in a majority of cases, you have signed a personal guarantee. Now, you will be surprised to know, or you may be knowing, about 12 lakh crores of personal guarantee cases are pending under IBC. 12 lakh crores. Now, this case is also going in the Supreme Court, and because of the Supreme Court case, these cases are not being pursued. But someday the Supreme Court order will come. I expect this order to come in the next 2-3 months. But someday this order will come, and the day this order will come, this personal guarantee cases will become active. So I think it is in the promoter's interest also to ensure that their debt does not increase, or it can be some stop can be put to it, and therefore I would like to request you to please consider also coming under Section 10 at an early date, so that you have less problems. 2 or 3 speakers were talking about IBC 2.0. You also know that Ministry of Corporate Affairs has put a discussion paper in the public domain. You also know that we had also done a colloquium, and we have also put that report is also available in the public domain. We also had several meetings of the law committee, and some of you are members of the law committee, and you know the deliberations that we had in the law committee. And you must have seen that the entire set of work that we are wanting to do is to reduce delays. Every proposal that is being formulated or that is under consideration is to reduce delays. We had looked at cases why delays were happening, and we are prescribing something. We are prescribing something so that excessive litigation is reduced. And when litigation gets reduced, delays should get reduced. So we are making it more clearer or more transparent. But we are also mindful of the fact that, over-regulation also kills the sector. Shardul ji had talked about value maximization and the time. These are very difficult topics. And I personally feel that there is no one size fits all. There are cases where perhaps the COC will have to take a decision. And there are cases where time is of great essence. If you look at the first few cases, first big cases, you would see that multiple rounds of bidding or negotiations had happened. And over-regulation is perhaps also not the solution. And resolution is a thing which requires innovation. And it should be left to the RPs, it should be left to IPEs to do this innovation. I'm very happy that Mr. Iyer has done I thought that he will talk about that innovation today. He's done a great innovation in one of the projects that he's doing. Innovation is absolutely necessary as we take IBC forward. The Chennai bench of NCLT has recently passed an outstanding order where they have said that a part of Hindustan Photo Films can go into resolution and the part can go into liquidation. That is innovation. And I'm not saying that can be done in every case. But that is an innovation that we should encourage. There are large number of, we had a regulation saying that you can now have multiple resolution plans. There is a unit or there is an industry which has a unit in Odisha and a unit in, let's say, Gujarat and a unit in Tamil Nadu. Now, we don't have those kind of entrepreneurs who would take up all the three. And people would be interested in one particular unit or two particular unit. Why shouldn't we allow this innovation? And you as resolution professionals are the best people to do this innovation with the help of COC. So we should encourage innovation and we should desist from over-regulation or writing everything in the act. In India, we write everything. That is our habit. So we write a very big law. We write big regulations. If you look at other countries, they leave it to the professionals. And I think a time has come that we should leave a lot of things to you. Mr. Haldia had talked about some disciplinary proceedings or issues. He has given me a list of some issues which RPs are facing, and RPs want clarity. We will certainly try and give that clarity, because you should have clarity. You should have clarity in your mind. You should not be thinking as to, if I do this, this will happen. There should be sufficient clarity, and we should try to give you sufficient clarity. Even if our clarity does not have legal backing, we are not the judicial authorities. But we should give you some guidance, and we will give you that kind of guidance or that kind of clarity. The last point I'll request you is, laws will change, regulations will change, all that will happen. But even without that, delays can be reduced. Even without that, delays can be reduced, and I'll give you 2-3 examples. At least in big cases where the financial creditors, file under Section 7, which actually go into CRP stage, they also give the name of a RP. And the RPs are involved right from the beginning. I know I've talked to a large number of RPs and they are involved right in the beginning. But our regulation says that please file a default certificate given by the information utility. Even today, in majority of cases, you don't file them. You don't need to go anywhere to take out that certificate. It is available online. That certificate will help the adjudicating authority in taking a faster decision. That is all. And if the admission process is faster, it will reduce delays. We have a large number of cases where after the resolution plan has been finalized by you or by the COC, and there are cases when even after it is submitted to the A, claims are submitted. And these IAs are filed before the A, and then the A says, please look at this claim. I mean, I have seen large number of such cases. Now, what does the RP does? He issues a notice and then waits for the claim for the next 30 days. And then whoever files the claim, he admits them, he looks at that. We have issued a regulation and we would like to request all RPs as to why don't you proactively take claims? Those claims will come one day. Please don't think that those claims will disappear. If you don't take those claims will be written off. It does not happen like this. Those claims will come one day. And when they come one day, they are going to delay the process. So at the beginning, when you are inviting claims, you have some kind of a balance sheet of the CD, old balance sheet, but you have some kind of a balance sheet of the CD. Why don't you write to everyone stating, I have taken over the project, please submit claims? There are cases in real estate where you have the list of home buyers and still we are waiting for the home buyers to file claims. And then what happens after the resolution plan is prepared? Some home buyers will file claims, and that will delay the resolution process. That is all that I'm. So what I'm trying to say is, why don't we try and do things proactively so that delays are reduced? That is all. I mean, that is all that I'm trying to say. There are cases which I have seen where there is a form which is to be submitted along with the resolution plan. Form H, I think. Form H is not properly filled. So my only request is, if we do our work professionally, if we do our work in a more diligent manner, perhaps even within the existing laws, within the existing regulations, we can reduce delays. And each month of delay reduction will lead to, if this 1.8, even if you do not agree to this 1.8%, it will lead to 1% or 1.5% increase in the valuation or reduction. So, if we are able to save, let's say 1 year in the entire process, admission, resolution, approval, if we are able to do that, I am sure we will get 10-15% more. For those of you who have seen the economic survey which was presented in the parliament, the figures given in the economic survey shows that IBC did more than what all others did. The recovery under IBC was more than the recovery of everyone else, all other things combined. And I have the provisional figures with me, which will be published later on. We have done better than last year. 22-23, we have done better than 21-22. So our performance is not going down. Our performance is improving, but there is a big room for improvement. And if we can just reduce delays by 1 year, and you are all so, you are professionally so good. If you do it, you can definitely reduce delays by a year. If you reduce delays by a year, we will gain another 5 to 10% at least. Another thing, last point I want to make is, another thing that has happened is, initially we had a lot of big cases, 40,000, 50,000 crore cases, and most of them were in the steel sector. Now, that was the time when lot of foreign companies wanted to enter Indian steel sector. Today, vast majority of cases are below 1,000 crores. So it is more difficult to achieve what we have achieved 4-5 years hence. If we do 140,000 crore cases and if we do 1,000 crore cases, I mean, we have to work 40 times to achieve that. So you have to keep this in mind. But the advantage is that we have the experience of that 40,000 crore case. We have the judicial pronouncements and the precedents of that 40,000 crore case, which we can use in a 1,000 crore case in a more easier manner. But there are two sectors which are picking up at this time. One is the power sector. India had lot of power surplus in the last few years, but it is said that in the next few years we will not have that kind of power surplus. So there are large number of power projects which we need to look them up. Real estate has also started picking up in the last 1 year or so. We have about 250 big real estate projects in our IBC framework, and real estate has started picking up. So we need to look at those real estate projects, and perhaps they did not have bidders in the previous times, but they have bidders in we should get good bids for those real estate projects. So I thank you again for inviting me to this conference and for listening to me so patiently. Thank you very much.
Thank you, Mr. Mittal, for that excellent perspective that you have provided as a regulator, and also dealt with some of the facts which are unique to your knowledge and which are still to be published and announced. I think if one looks at the dialogue that has happened so far, and I am not going to repeat what I said, the broad discussion has clearly proceeded on the footing that we do need to recognize that the IBC has been highly successful, number one. Number two, that it has created a whole new regime of new professionals, like the resolution professionals, like the valuers in relation to distressed assets, and so on and so forth. And that should not in any way be minimized or underplayed, because that is the way and manner in which we have come to identify other problems which sort of have been under the surface, and trying to improve on the efficiency of what we have already achieved. So this is not in any way, and should not in any way, be treated as a denigration of what we have done. We have a lot to celebrate, and I think that came across extremely clearly from all the three speakers on my left, that is Mr. Haldia, Vijay, and Siddharth. And I thank them for that approach. I cannot thank Mr. Ravi Mittal any less. And in fact, his whole presentation has also been on the issues of how much focus is being taken by the IBBI in matters concerning delays across the system. And as he rightly said, it's from filings, admissions, CRP, some forms which are bad, then the whole process of litigation, and of course, the implementation of the resolution plan. It's a very happy sign to know that from the IIM project, his information is that there is a far greater success which is embedded in the post-revived companies. And that story has not even been said. And I am sure that once it is in the public domain, that will have a further bearing and a congratulatory space for the IBBI and all the people in the, all the stakeholders in the process, because it's not just one factor. All the factors have contributed to the success. And that's certainly something to celebrate and to pat ourselves on our backs in the way in which this has changed the paradigm, the way in which it has eased the business, the way in which we can justify how our ranking in the ease of business index, which of course is not now going on, had improved such by leaps and bounds, and that is truly justified by the facts on the ground. The whole process of innovation, which Mr. Mittal spoke about, is also an extremely important concept that he has reminded all of us, because what it shows is that, and he mentioned it in the context of over-regulation. And I think that's a very, very important issue and point, for the reason that most professionals who are subject to the diffidence test, as Vijay put it, are always worried as to if they innovate, what's the consequence? What will they face? What will be the COC's problems? Will this go into CVC? Will it get up into the Parliamentary Finance Committee? These are concerns and the issues which restrict innovation. But if you look at the legislative change several years ago, the change in the definition of resolution plan was a clear indication that there is a scope for innovation. And that is now coming to fruition, as the learned chairman mentioned, that you are now having companies being split, part revived, part liquidated. All that was not permissible before. And I think these judicial steps of innovation are incredible steps to modernize the way the IBC is functioning. It also, therefore, gives the opportunity to bidders that they don't have to take everything. They can take part, and somebody else can get another part. So the structuring of the IM has also to be cognizant of this fact that it is not just all or nothing. So this is an extremely important issue, as the learned chairman mentioned. I think all the speakers have clearly mentioned that there has been a behavioral change, and that's the most critical issue which must be subject matter of any evaluation. That if the ecosystem and the behavioral issues between debtor and creditor have changed for the better, then that's certainly something for which congratulations are due. The fact, and I think it may be a consequence of Section 29A, that you could lose the company and that you could therefore lose the opportunity to actually bid for more companies, and in some sense seriously lose rights in relation to either ownership or management, has in some sense triggered the better behavior of the debtors. I remember a statement which was quite often used in SICA, it's a beautiful statement: there are only sick companies, there are no sick promoters. And I think that's what the chairman has blasted apart, that you are now having the fear that you are going to be a sick promoter. And it's a certainty. It's not something which is a question mark where you could drag the process and you could really save yourself because of delay. That's not a reality anymore. And therefore, I think the chairman has rightly pointed out the emphasis of what's going to happen when the personal guarantee cases are really judged upon by the Supreme Court. What is dormant and what is sort of under the radar. And he mentioned the figure of 12 lakh crores. Correct, sir? 12 lakh crores. That bulk of cases is going to explode on the NCLTs. And there will be all sorts of devices which will come to the fore. We have so far not really worked on, and that's one area where we could do better, is on the tracing of assets and the aspects of tackling fraudulent processes or overpricing, underpricing, all those kind of issues. That is as important as the attack on the personal guarantors. If the cases have been so long under the radar or have not been decided, it is possible that the debt has been effectively restructured and a new debt structure is continuing with the company. One of the big issues which the NCLTs and the resolution professionals will face, and the COCs of course will face, is that variation which has resulted in the new company continuation or the old company continuation is a discharge and a satisfaction, and therefore the guarantor should not be called upon to please. I'm saying that there may not be any merit in that argument, but that argument will certainly be raised. That's a change without the promoter's consent, and under the law of contracts guarantees, it provides that if you do something which changes the contract frame in a guarantee, the guarantor could be discharged. It is equally defensible by saying that, no, this is a change by virtue of law. It's a change by virtue of your conduct in running the company. It is perhaps driven by your misconducts in siphoning funds, in really choosing the wrong business, and you're paying for it. So there are points both ways, but this is certainly going to still arise after the Supreme Court's decision in relation to the guarantees. So there is still a lot to evolve in the space of the guarantees law. I agree with the learned chairman that the experience of having large cases of 40,000 crores plus is a rarity, and it's not something which we will repeatedly see. Yes, there are cases where large stakes are still there. They are still embedded. There are issues which are falling within the privatization regime, falling under DIPAM, but having a lot also to do with incipient sickness. The Parliament has also reiterated just 3 days ago that there should be focus on reviving and or restituting companies which have effectively lost their competitive spirit. So there is a lot which is in churn, may not be only in the IBC, but all related to stressed assets. And I think it's interesting times as I see. The chairman has also been kind enough to lay out a business proposition to several of us here present by indicating that the next horizon for a number of cases is going to be power and real estate. Thank you, sir, for that suggestion. I'm sure the people sitting in this audience will definitely take heed of that, and thank you for opening our eyes to that business opportunity. So this is what I believe are the outcomes of today's discussion. I thank the chairman and all the panelists on board for their excellent contributions to this discussion in the opening session. I look forward to much more in the following sessions, all of which are extremely interesting and are capable of throwing many more issues which need to go to the IBBI as a matter which is arising from business, not just the implementation of the Act. And it will certainly help IBBI to recognize different situations which need to be looked at either through the IBC or through special committees which the IBBI sets up in combination with the Ministry of Corporate Affairs. So thank you all for patiently hearing all of us, and I am indeed grateful.
Thank you, everyone. This has been indeed a very enlightening and illustrious inaugural session, and I'm sure the audience is left with lots to ponder and think through the day. Thank you once again. I request all to please remain seated. We are starting off with our next plenary, immediately. Thank you. Next, we have our moderator, Mr. Anup Rawat, partner, Shardul Amarchand Mangaldas and Co. Anup, can we have you on stage, please? We have with us Mr. Sandeep Negi, who's a subject matter expert on IBC. Mr. Negi, please. Please join me in welcoming Mr. Siddharth Srivastava, partner, Khaitan and Co. Last but not the least, Dr. Sanjeev Kimawat, Group General Counsel, Vedanta Group. I would like Anup to please take over and start the session. Thank you.
Hello. I think timely resolution is the essence of IBC, so we'll just keep that in mind while conducting this session. I will try to wrap it up within the timelines. I wanted to say a few words before I introduce Mr. Sudhakar Shukla, but I'll leave it for the panel discussion. So I'll straight away request Mr. Sudhakar Shukla, who is the whole-time member, to open the session and give his opening remarks. Thank you, sir.
I thank Confederation of Indian Industry for giving me this opportunity. It is always a difficult task after such a insightful opening session to come in and give the thoughts to the second session. I had some structured points to make, but I thought, swayed by the ideas which have come in the inaugural session, would be digressing a bit from, not as a response. I thought criticisms are always welcome, and that is the spirit which moves us. So the points which emerge are always taken good note of it, and try to see our drawing board is always with issues to ponder and move on. I just wanted to start where Shardul Shroff sir left his opening remarks. He said, investors' confidence on insolvency regime is shaky. That was the last line he made. And there is a big no of investors to IBC. I thought the kind of spirit we demonstrated during last 1 hour or so, and large presence of all the stakeholders, including the prospective RAs present in the hall, and some are taking leisurely tea outside, but interest is very much there. So continuity and change is the law of the nature, as they say. An economic law always evolves. We say past is basically relates to your experience, and present is basically experiment, and the future is what expectation you build on the basis of these two E's which I said, experience and experiment. So if you see the dashboard of wish list which has come out in the public domain, and other ideas which are floating around, we can safely say that expectations are fully loaded for action in time-bound manner in near future. Why the change has been necessitated? It's a gradual process anyway, but some basic issues have emerged which needed to be addressed. So I will be trying to touching those a bit. There are at least 5 imperatives which drive this ethos of change. One is the structure of the living law itself. This is a illustrious gathering. We need not illustrate on what economic law and experimentation mean. But definitely, law is evolving and you are responding to the need of the market. So that is very clear that when you are responding, you are always behind. So law also evolves to catch up with the expectations of the market. Then added to it is jurisprudence, which comes in the form of various judicial pronouncements. That also makes us alert that law, as being defined, redefined, needs to balance the legislative intent and the market expectation and how it is being interpreted. So those things come into play. Second aspect which goes into thinking is development of the world order. World order is limited to insolvency space, and here we see that always we compare India, US, UK regimes of insolvency, how we fare vis-a-vis them. And that also gives a lamppost best practices, whether we have to inculcate them in our paradigm or not. So how things have moved and are moving under the aegis of United Nations is very important. And we always keep an eye on what is happening there so that we can also get prepared to be in line with the developments internationally happening. So if you see unilateral model law of cross-border, it has been mentioned in the opening remarks also. It is like, if you see your discussion paper or FCA, which came sometime in December, it included and hinted what kind of cross-border regime we are expecting. A person, an intellectual, may be having difference on particular point of implementation, but on principles, I think there is no dissent that this is a way to go, and we have to cross that mile, and cross-border regime has to be in place. If you see how it has unfolded, 57 jurisdictions are quoted. But if you compare 57 jurisdictions, despite model law guiding them, not one jurisdiction matches another. So that throws caution to the regulator here, that designing principles have to see the seed of the soil are taken care while we are talking about cross-border. So that is why it has taken a while, and it is taking a while how to proceed further with that. Then group insolvency has been debated internationally. The model law is out. To my mind, no country has adopted it so far. In the morning session, big case has been made. And we also think that cross-border cannot be implemented without having a clear understanding on the group insolvency. And that is why I think the drawing board is giving much more priority to group insolvency at the domestic level first, before crossing that mile towards the cross-border insolvency to be adopted along with the group insolvency regime for the international companies. Third development which is taking there is unidroit principles. If you have heard the finance minister's statement yesterday in the Washington, your cryptocurrency is an issue of regulation which unidroit principles are trying to address. But FM has gone on board to say that G20 has to come out with a concrete strategy to give this innovation theme and the regulatory framework how to deal with the exigencies associated with the cryptocurrency. Next issue, which is not being debated right now, but there are some murmuring, is the climate change issues. We are talking about brownfield projects. So I don't think there would be any dearth of brownfield projects in time to come. But greening the brownfield project is a major problem which international community is yet to address. So the third issue of giving some jerk and deviation and needing some redressal has been the COVID impact. It has been said in the morning about suspension. Suspension, no doubt, was a knee-jerk reaction. But suspension of IBC was not there, which was interpreted in the morning. I thought that has to be made clear that it was only the fresh admissions which was stopped. Otherwise, IBC and all its functions were continuing. So old cases were being decided. Anyway, admission times take very long time, maybe 2 years in some cases. So that admission, even if you stop gate that, you have a very credible pipeline to deal with under the IBC during that period of COVID. That was not the main concern, but concern came from the fact which data is coming now, that from the point of COVID, like average time taken for resolution was 460 days. And post-COVID, it became all of a sudden 700 days. And now at today's data it is around 750 days in resolution. If you talk of liquidation, then you add another 700 days, so over 1400 days maybe. This was the one impact. I cannot say directly coming from COVID, but if you have the analysis of excludable and non-excludable time frame, you will get some idea that this is the time when excludable time has been added to the timeline in a big way. And second impact, whatever we say about whether value maximization is a goal or not, the impact data suggests is that our realizable value actually has drastically gone down from 30% to 16% with the advent of COVID. So when COVID arrived, we were at 30% of realization. When COVID peaked, we came down to 16%. And now last 2 years, as my chairperson was also referring to, data is encouraging. Recovery rates are now touching 25%. But more important aspect of this debate is preamble. We know that preamble says time-bound resolution. But time-bound resolution itself has inbuilt concept of value maximization. And this is supported by the data actually. This time taken and value realization is inversely proportional, and this is like any time anybody can make a check on what results we have got in 641 resolved cases. So that maxim is very clear. Why we emphasize time bound? We don't say value maximization, but value maximization is inbuilt in the ethos. We cannot shy away. Our performance in the newspapers, by the Standing Committee of Parliament, always has been done through one parameter: what is the haircut? So we were not able to hide behind that our preamble does not say it is not important. But this is how we are forced to defend ourselves through recovery rates. Another factor which needed or guided us to bring some imminent change, is the emerging jurisprudence actually. We were very fortunate in our initial years that we got innovative judgments, and we got Sridhar, and we got Swiss Ribbon, you name, and there were so many judgments plugging the loopholes, stabilizing the regime. But all of a sudden there is a series of judgments which are being actually in a bit affecting the spirit of the preamble which we are talking about. So we have Vidarbha, we have Venus Recruiter, we have Rainbow. There are a series of judgments. Like when we went again to Supreme Court on Vidarbha, so it was clarified that it is a standalone case, and the facts of the case are so. I am not a lawyer, but if you see the implementation of the higher court's order become a binding for the lower court. The moment it has been said that Vidarbha, you have to give more options in particular circumstances, lower courts, especially NCLTs also, started returning the cases of admission for re-examination. The clarification has come now from Vidarbha that it was a standalone, but still, I think there is a apprehension that we have to do more. So that is why this discussion paper says that there is a need for clarifying that aspect, and Section 7 application is firmly based on the evidence being provided by IU, authenticated default certificate. And if that is not available, then you can see the alternatives, but this has to see. So drawing inspirations from these many inputs which we are getting, three vital themes are guiding us basically. One is your sandbox approach, which Chapman was referring to be wary of over-regulation. Sandbox approach gives more flexibility to the regulator to react to the situations in a manner it is supposed to react. Right now, everything is tightened by the code with very little flexibility with the regulator to come through regulations. So we needed a act like Gift City, 7 pages act, leaves everything to regulator. Maybe some may criticize that this will involve some kind of regulatory capture and you would be again not working in a spirit which is the intent of the legislation. But that gives you the needed flexibility to respond to every situation. Second discussion point was behavioral change. Chairperson has already alluded, it is not only at the level of entry, but each and every stage stakeholders have to change their behavior to see innovations are done in a manner to serve the spirit of the IBC, which is enshrined in the preamble itself. And the third aspect, I thought, underlying philosophy which is going into this is your IT enabler is absent right now. We heard in the budget speech massive push is coming towards e-courts, and we hope that NCLT would be also benefited through that announcement. But that apart, actually there was a need for IT enabling scenarios, not only at the level of delivering the judgment, but at the level of entering each and every data which is machine readable. So that was a necessary thing which we have to think about. On discussion paper, basically, I will briefly end with that. Basically, that is in the public domain. But main thrust and added some other issues which are on the drawing board. Main issue we are also trying to address is to develop the stressed asset market to facilitate, incentivize RAs. And since this is a CII's conference, so I want to give this assurance to RAs that many more amendments are on the card, are under consideration, which would be helping their cause in moving forward. Shodul Saab mentioned about information. Yes, information is asymmetry is there. We are trying to innovate the information memorandum the way it is presented. We already brought out the regulation for the marketing of the CD, which was not being done earlier. We are also trying to see that if you had a license and agreement from the government and other OCs, that agreement till the lifetime expires is honored. And another thing is basically section 32A has been referred, but we are also trying to make more clarity that your civil liability over past due ceases to exist on the date of resolution. So whether you have moratorium or no moratorium, that ceases. So that is the concepts which are on the drawing board. I thought I would be briefly mentioning this. Rest my panel would be discussing the topics assigned for the day, and given the opportunity, I would be also trying to address some of the issues. Thank you very much for this opportunity.
Thank you, Mr. Shukla, for the insightful opening remarks. I'm aware of the time constraint that we have here. Some of our panelists also have some other commitments. I wanted to begin, this session by actually thanking IBBI, for being such a dynamic regulator and bringing out regulation that meets the requirement of the market. We have seen how proactive IBBI has been as a regulator. They've been quickly bringing out the solution which suits the market requirement. They have, in many cases, seen the difficulties that the individual corporate insolvency resolution processes were facing, and they have come up with solutions like allowing the resolution plans for different assets, bringing in the concept of multiple resolution plans. Of course, there are certain issues around implementation, such as how would you take care of the dissenting creditors if you are doing the individual resolution plans. Can you do the resolution plan for different assets sequentially, or you need to do it simultaneously to take care of some of the critical issues such as the dissenting creditors. But all of these issues actually create more and more opportunities for us as a professional. This whole IBC has actually introduced so many practice areas, and all of us are thankful for that. In fact, we are thankful that this has occurred in our times. I just wanted to open up this session by asking a few questions, and I know, Sanjeev, you're anyways running short of time. See, we know that resolution can't be seen from the perspective of how much debt the company has taken, but it has to be seen from the perspective of what is the value of the company today, what it can sustain, and whether it can remain viable in the future. So from that perspective, of late, there have been a lot of discussion about how some of the resolution plan values that are being offered are either around the liquidation value or below the liquidation value. What are your views as a resolution applicant who's very active in the insolvency space? How do you see that as either some kind of a bottleneck for presenting the resolution, or how does it impact your approach for offering the resolution?
Thanks, Anup, and I know for sure that you have changed the format because of my difficulty in terms of going early because of some other commitments. So first, let me thank CII and the organizers for inviting me to share my views on this relevant topic. I heard the earlier session. I heard Mr. Shroff. I heard Shuklaji. because this is the only platform, on which I would be sharing some thoughts, and some thoughts which are relevant in terms of the evolution of this law. So I would be slightly wild in terms of my thoughts also, so don't worry on that. Also, since I would be leaving immediately after that, so whatever immediate thoughts which are coming to my mind, I would be sharing that just now. So Anup, the way in which I see as an industry representative this law, we were all very upbeat about this law, because this was one of the finest piece of legislation which we have seen in the recent past, that with definite timelines, with a definite plan of action, and with the sole purpose of revival of a company. Now, somewhere we have done injustice to this piece of legislation. And this injustice has happened. And I'm using the word innovation. Mr. Schroff also used the word innovation, and some of other also. Because this innovation happened not at the legislative level. Innovation happened at the court level. And that is what has led to all these complications in terms of delays, in terms of interpretation of law, and so on. Now, if you notice, you said that, what is on the liquidation value and all that. I'm just, giving a thought on this. Let's accept this reality that this is a socio-economic legislation. This legislation is, in a way, a reflection of the state of economy. So whatever value you are fetching, that is what the value which is available in the market. And availability in the market is based on who all are the acquirers and who all are the assets which are under liquidation. Now think about it. With this immense unpredictability and uncertainty in the process, are we rightfully inviting the acquirers and purchasers? Answer is definitely no. Forget about the global investors. Even Indian investors are apprehensive about the whole process because of the simple reason that there's a full, delays, and courts are experimenting and innovating in the whole process. And here I'm giving some wild thoughts on this. Is it really an adjudication process? And the difficulty here is that we are not distinguishing between resolution process and the distribution process. Most of the litigation which are available in the courts, and unfortunately, all this jurisprudence is getting developed at the Supreme Court level. Left, right, center, the judgments are being passed, and ultimately at the Supreme Court level, the jurisprudence is getting developed. Now, most of these cases are on the distribution part, and that too of distribution of what numbers? 5 crores less have been paid or 10 crores less have been paid. Is this the way to do justice to this piece of legislation? So the suggestion which I'm giving is, and Mr. Schroff, slightly wild one, and I say that is it an adjudication process where the resolution professional is a regulated entity? COC, in a way, is a regulated entity. There are two regulated entities who are approving the process. Law says that whatever COC has approved, let that be approved by NCLT. And if Section 30 has been complied with, if the resolution plan is before NCLT, as far as the approval of the resolution plan is concerned, I don't think that this is an adjudication process. This should only be a registering process. The moment you make it a registering process, you will be avoiding multiple litigation which are happening today. Yes, I can understand the distribution process can be one such issue where there would be challenges. There are vendors, there are all those frivolous litigators, etc. Those would be coming up. Let that be an adjudication process if that is required. But then if you say that the law envisages the COC is the commercial wisdom of the COC is supreme, then let's respect that. Let's respect that, and let that be not an adjudication process, a registering process. Now, I think one more important aspect which I wanted to just highlight is that somewhere this frivolous litigation in the name of public trust, public interest, that should be avoided. And just appreciate that all this litigation is not by anyone else, but by these same promoters. These are all sponsored litigation. I think somewhere there should be some consciousness in terms of addressing this issue. And very briefly, last point is, I think today the adjudicating authority, the way in which we are seeing is, it's coming from a diverse background. And that diverse background is not giving them the full understanding about the economic laws, the way in which the corporates function, or even the basics of corporate laws. I think a serious training is required as far as the adjudication authorities are concerned. I think this is what I would be very briefly saying, and just wanted to take liberty of going also. Thank you very much. Thank you for listening me patiently. Thank you very much.
Thanks, Sanjeev. I think the weight has added to the anguish, but yeah, all of these are very pertinent issues, and I think the critical ingredient for this recipe of resolution is the resolution applicant, the investors, and therefore I think there has to be the maximum comfort, confidence amongst the investor community to make the resolution successful. Otherwise, whatever law we introduce, whatever regulation we introduce, I think it will not yield a result. For us as a practitioner also, I think everything depends on whether there is going to be enough interest among the investor community and whether they are going to resolve it or not. So thank you so much, Sanjeev, for that.
Thank you.
I think there is no dearth of the enabling mechanism under our law. Whatever aberrations that Sanjeev spoke of, and they are quite frequent now, but even with those aberrations, I think it's a beautiful law. Never ever you had the statutory dues relegated to such a level, below even the OCs. Never ever you had the statutory recognition of continuation of the permits and concession during the insolvency processes to maintain a calm period, to allow a resolution to take place. So I think law is beautiful, regulations are beautiful. I think we just need to strengthen the system. Now, taking forward, this is in a very, very positive and an optimistic way. There are lots of changes that have been introduced recently through the regulations, which also include, and I mentioned it in the beginning of the session, which allows the sale of the different assets through different resolution plans. It's a very, very welcome introduction. I just wanted to pick Siddharth's brain on this, that when we look at it, and we are, in fact, as we speak, we are doing some transactions where we are running this as a process, but there are certain inherent issues there. If you have different resolution plan, how do you take into account how do you resolve the dissenting creditors issues, the operational creditors issues? So, Siddharth, what has been your reaction to some of these introductions? Which are great introductions with these kind of operational challenges.
Sure. Thank you. And thank you, CI, for having me over. Just before Anup, we go into that, just one picking up from where Dr. Gemawat left, just the plight of the bidders. Okay, just want to put up one point because I think it needs a little bit more discussion. Is besides the other issues which have been faced by the bidders, and of course I agree that IBC is a great law and it's done a lot for reviving the stressed assets in India, but and I'm no tax lawyer, so but we have seen a lot of bidders being slightly apprehensive in terms of what is the tax treatment when they pick up a stressed asset, and there is some bit of lack of clarity. People have difference of opinion, people have different interpretations, especially after the post budget. There is some bit of lack of clarity on impact of tax on loan waivers, how one deals with that. So that is one issue which needs to be definitely addressed. We have tried from a bidder side, we tried to sort of address this issue by curating the deal as an assignment of debt, but we understand that at times the lenders do not want an assignment of debt because they're concerned about the personal guarantees. So if you come up with a tax sufficient structure, it is also sometimes met with a lot of discussions, I would say, vis-a-vis COC, because they do not want to give up the personal guarantees or corporate guarantees, and rightly so. I'm not saying one is right, the other is wrong. I'm just saying because of these issues, it casts a lot of doubt in the mind of the bidders who would want to take up stressed assets and what would be the tax implications. That's one pain point. Coming back to Anup, what you have said, and the concept of liquidation as a going concern and other changes which have been carried out or changes which have been made, I have personally very strong views on this. I don't think liquidation as a going concern works really well because of various reasons. I personally feel that it somehow sometimes incentivizes liquidation. The moment, and I agree with Mr. Shroff, I think he also touched upon this in the first session. The moment you say and you give an option that there's an option of liquidating a company as a going concern, you are basically trying to say that even if things don't happen in the CIP process, you have another option. And whether that option is viable or not, I'm not very sure, because there is an absolute lack of clarity as to whether you will get all the reliefs and concessions when you are submitting a plan under liquidation as a going concern. That's point number one. Whether you will get tax benefit in context of a liquidation as a going concern, that's another issue. So whether we have seen a lot of successes in terms of liquidation as a going concern, I don't think so. Whether it further has the capability of incentivizing liquidation and further delaying the process, I feel yes. So there's some topics and some aspects which needs to be perhaps reconsidered, and I thought this is a good forum to perhaps pick those issues up. Also, liquidation as a going concern has a very sort of limited window, and I'm not sure practically how it would be possible for anyone to achieve that. At the same time, the focus would be much more on strengthening the CIRP process to ensure there is value maximization for stakeholders and let the liquidation be as is, and which would perhaps provide a lot of clarity in my view. As far as the other issue which you picked up on having multiple plans for multiple assets, I think that a lot needs to be done, though we have enabling provisions in law, but there is a lot of lack of clarity, and I agree with you with respect to the plight of dissenting financial creditors. So I think the law needs to be thrashed out clearly before we even go down that route. In some cases, of course, one is practically exploring those ideas, but it needs a lot of assessment in my view.
Yeah. Thanks. Thanks, Siddharth. I would just again say that, despite all the shortcomings, I think it's very heartening to see that not only the government, which frames the law, but the regulator, they have been so much proactive in trying to find solution for various issues that insolvency faces, and especially in the context that insolvency comes under a very different arm of the whole government, and there are so many other government departments, the other regulators that that have important role to play in a successful insolvency resolution. So the recent income tax circulars which have recognized the claim resolution during the insolvency processes, and the internal, I think the notifications to their to the various sub departments for filing of the claim on time, it's a recognition that yes, the tax claims have to be resolved under the resolution process. Similarly, the whether it is SEBI or RBI, CCI, I think all of them over these last 4-5 years have helped tremendously in implementation of the insolvency resolution process. There are a lot of work yet to be done. We are seeing there are so many areas or like telecom or oil and gas, where the regulators are yet to come to terms with the effect of the resolution under the IBC processes. So I think it's an ongoing process, and thankfully we are moving at a very fast pace on this. Now one of the other areas which I think hampers the resolution process and the efficacy of it is the availability of the information in the corporate data. What we have seen is most of the times that when the resolution professional joins, either the information has been destroyed or the existing systems have been tampered with, which causes tremendous difficulty in preparing a healthy database, which is very, very important for the resolution applicants to evaluate the whole company. Now we have Sandeep here, who is part of Deloitte and have been assisting the insolvency professionals. How far, Sandeep, do you think this issue is affecting the successful resolution? What have been your experiences on this?
Yeah, thanks, Anup. And this is, as I think the opening remark Mr. Shroff has mentioned, that timely maximization. So it's a kind of linked also. There is a priority. One, timely is important, and value maximization, both are important. But the first part of timely is very important because that's how actually you protect the value, preserve the value as well as maximize the value. Now, is the IM or the data room that typically a bidder would ask for, which is the title of assets, the financial information, the past records, the MISs. The stronger it is, the better visibility a bidder gets, and you're able to realize. And we have seen in some cases where the data room was pretty strong, the IM is pretty strong, we were able to get a very good competition in terms of the bidders as well as the value we are looking for, the COC is looking for. So that's one part of it, and second part of it is the information all is available in a fashion which helps us prepare all this. Also at the same time we can prepare in terms of reaching out to the potential claimants, OCs, home buyers, as somebody was mentioning, and reduce the type of kind of litigation subsequently falls. And recently we are also seeing cases where the financial records are not mentioned, so the compliance ROC is not there. That becomes a big challenge, getting the P&L balance sheet audited, which is also historical, and then complying a lot of ROC matters where we are left with one or two directors, not even as per the Companies Act, where you need at least 3 directors in the company. So all that hampers the normal process. Well, this itself takes a lot of time rather than focusing on the resolution process.
Thanks, Sandeep. But I think this is one area. I mean, and I would request Mr. Sudhakar Shukla also to look at, because currently Section 19 is not providing enough support to all the IPs and RPs. I see a lot of IPs here nodding their head as well. Section 19, allows the resolution professional to approach the adjudicating authority to seek the direction against the existing or the erstwhile management. But somehow, because either you can say is the heavy load that the adjudicating authorities have, or you can say that the kind of complicated complicated management that they had created, that the exact allegations are difficult. It's very difficult to prove sometimes, who was responsible to identify the person against whom the directions are required. So the non-availability of data for the RP is very, very serious, and it's actually, in our experience, have been affecting a lot of resolution processes. One more point to add to that, sir. You mentioned about the changes in the information memorandum requirement that you had mentioned in your opening remarks. If you could also give some insight into that as well. Thank you.
Thank you. I think I will 2-3 points have been raised. One was of parts of plan. I thought in 2 parts basically. Gamawat was mentioning that a lot of litigation around proceeds and not on the factuals related to the plan itself. So it has to be in 2 parts. So I wanted to say that, but I thought it's a part of the discussion paper in public domain. That parts, the way he was mentioning, is already a part of this discussion paper, which is feeding the government about the reforms which are forthcoming. So that part is one. And then he was also mentioning about the frivolous application. It's a strong, actually, if you see that paper, a strong focus, as chairperson was saying, was on curtailing the delay. So delay curtailment, we thought frivolous applications have to be stopped and penalized as well. So those are very much part of the recommendations which are being discussed. So when it will happen, how it will happen, to what extent it will happen, government will take call. Third issue is going concern. Actually, Going concern, again, actually, when we say the preamble is a guiding principle for us, preamble says restructuring, and preamble is silent about liquidation. It says, and we presume it's a liquidation remote solutions it is talking about. So when this concept of going concern came, that if due to some like some oversight and due to some problems associated with the resolution, if company is being pushed to liquidation, then this option should be available to explore. The point is that, like, you have 2-3 bidders for the CD, and one is successful and his plan moved up but not implemented. There is a second and third bidder in line in the resolution process, but not like once it is decided that this CD goes to person A, RA gets it, becomes SRA. If he does not implement it, it's a normal code says that liquidation. So we are saying that we are not giving any opportunity to rethink to bidder 2 and 3 to come into the process and resolve. So restructuring and resolve, if that is the concept, we thought in such cases where clear-cut competition is there, second and third priority people are also there, why to liquidate assets when you also know that resolution is fetching around 30% of value and liquidation is fetching around 5%. So in between lies the going concern, and going concern, it is not very strong market traction, only 5-6 cases have happened. Results have been good, I can tell you that. 6, but takers at that stage is not like anything coming to liquidation is 29A bar person comes through indirect route and takes over as a going concern. That is not the data we have actually. It does not support that everything is going to going concern back to related party or 29A non-compliant. So that is, I thought, is a entry. But now you have allowed part sale. You have allowed fragmented the CD to be resolved within the contours of the plan itself. So anything which is non-realizable effectively will be moving towards liquidation. So for liquidation, it would be very less if you implement the regime as it is proposed in the document. So, and last point, I thought directions also, basically non-availability of the information from the CD owners. Now that is also very much part of the discussion paper, and trying to make it a cognizable offense if not parting with the information. So that is how it will move. How much would be accepted? It's a government's view on that, basically. Thank you.
Thank you, sir. Sir, I mean, one perhaps suggestion to consider. At the moment, the way the plan or the resolution plan is defined under the code, it says that it has to be for the resolution of a corporator as a going concern. Now, if we have to resolve some of the asset and rest of the company goes into liquidation, which is perhaps the most most feasible solution in some cases, then perhaps this change also need to be brought in the code as well to to align the definition of the resolution plan. Sir, I know that I'm aware of the time constraint. The one last aspect on the cost, sir. What we have seen is that there is a IBBI circular of June, I think 2018, if I'm not mistaken, which says that the COC need to bear its own cost. Now, I just wanted to highlight some of the difficulties that is being faced in many cases here, where the COC is a fragmented lot. In some cases, COC may comprise of the bondholders who may be individual bondholders. For them to contribute to the huge cost of running the entire CIRP process, it's too much to ask for. They are anyways staring at huge haircuts. So one perhaps suggestion from the entire COC community, be it the nationalized bank, private banks, or the bondholders, is that in the normal circumstances, if the company is not in insolvency, the existing financing documents or the bondholders agreements, they allow the lenders to recover or to charge the cost of either the recovery, enforcement, resolution on the corporate debtor. And it is essentially a cost which is in relation to the resolution. So to that extent, disallowing the committee of creditors the option of charging the cost that is necessary for a resolution from the corporate debtor, especially in cases where the corporate debtor has cash surplus, is something which creates a huge constraints. We have seen in some cases where the promoters or some other counterparties fighting the litigation in NCLTs, where they have good representation through good senior counsels, but COC cannot pool in their resources to fight that effectively, which ultimately leads to losing out case also at times. So this is for a consideration, sir. I mean, I know the IBBI stand is that the RP and COC should work together, and there should perhaps be one set of advisor. But because of the nature and the scope of the work that RP performs and the COC performs, there's a clear delineation. There's a clear divide on which categories the resolution professional cannot trade upon or cannot interfere with. For example, the negotiation on the commercial aspect of the plan, the feasibility and the viability checks, all these aspects which are clearly solely in the domain of COC. And there, they need the expert advice, professional advice, they need the good advisors to help them out with that. And there, they are facing tremendous constraint. So perhaps, sir, in cases where the corporate debtor can bear this burden, which is anyways, their obligation under the regular financing documents, I think there, perhaps one rethink on this particular aspect can be done, which is again, a step towards the faster resolution. Thank you, sir.
Thank you for this advice. Actually, we have noted this, but in deliberations in the past, it has been very clear that COC members are the main beneficiary out of the plan. And even if we say 2.75 lakh crores, which has been quoted in the morning, they should also try to build some amount sidelined for litigation funding, you believe. And litigation funding for banks, we have never heard that they have any constraint. Actually, in many of the cases where we were rather in tight corner that whether we should go or banks should go, we thought banks were always forthcoming in leading the fight in the Supreme Court. So that way we were very, and cutting down the cost of CRP is a primary motive, and then you don't know if we allow what kind of cost would be coming to you. Organizing a meeting in a 5-star hotel, I don't know. But if you see the judge, one of the case I can cite, one case came that, and when we read COC minutes, it came that this cost is a COC cost, not permissible under the regulations, but we are funding it through the kitty. And if IBBI comes to take notice of it, we will reimburse. This is the minutes of the meeting. So you can see. Why IBBI should always watch all the COC minutes, but somehow we grabbed that minute and fixed the things right, that this is not the way it should be done. But in moving forward, when all stakeholders are on board and COC is not yet regulated, you are saying regulated, but it's not regulated. So they have to bear the cost of whatever expenditure they bring in, because they are the main beneficiary as well. That I said.
So will can I, yeah.
What is the current status of unsecured creditors in sharing the proceeds?
You mean in resolution, in liquidation? Which one you are referring to?
What is the current status of unsecured?
Status means what? Waterfall, you know.
Even legal status. Legal status. So what are they entitled to?
If they get any share or not, what share? Who will give this?
See, everybody is aware of. We would say that Section 53 is there, that waterfall, and that's your bargain. Let us say that there was no resolution. What you had bargained for, you could have never dipped into the secured assets of the company. It would have gone to the secured creditor because you bargained for an unsecured loan. So perhaps this is a very sensitive issue at the moment because it is also sub judice. That is running. So sir, it depends. I tell you, see, it all depends upon the risk. For example, if you today invest in equity or debt, it's your outlook. Maybe in a risky investment, you get a higher return. In a lesser risky, in a protected investment, you get a lower return. That is why and I don't think it is correct to say that unsecured lending always happen in an unlendable situation. It doesn't happen like that. It all depends upon one's perception of how is the business, whether it is sustainable or not, whether it will be recoverable or not. So that way, even the equity investment will be. So it's a matter of risk, I think, and what you bargain for. I think that is what the IBC says that that is what you will get.
And if I can just add, there's actually no bar in the sense that there could be cases where a resolution applicant may choose to treat both unsecured creditors and secured creditors at par and give them whatever returns as per haircut. So that also happens. But there is also an argument to say that both form a different class. Both may be financial creditors, but secured and unsecured form a different class. Therefore, I'm differentiating. And this I'm talking about a resolution scenario. Of course, what happens in a liquidation scenario is governed by Section 53. But in the market, there are plans and there are stakeholders and there are bidders who have in certain cases chosen to treat them equally. In certain cases have chosen to treat them differentially on an intelligible differentia that they are secured and somebody is unsecured. So there is no fixed practice, if I can say so. It also depends on bidder, and there are all kinds of plans in the market, but there is a reason to differentiate also, as Anup has said. There is some sort of rationale.
I think there are a lot of sir, I think the chairman gave an answer to that. That you recognize the stress in the beginning, take the step. Perhaps at that point of time, if you take it, you also have the when the resolution professional comes at that stage, when the company can be managed and supervised properly. I think that's where you should or then.
My question is different.
Yeah. Sir, I think you need to look at, there are code of conduct for resolution professional, how they need to manage the company. And there is a COC which sits there and, take the regular update from the resolution professional. So I do not know the circumstances, but, if there are certain non-compliances, then, definitely you have the recourse under law.
And also RP cannot walk away from the liability in terms of compliance with applicable and running the company properly when he was running it. So therefore, if certain non-compliance have happened,
sir, I think we'll deal with these questions post. Sir, this is not the shortcoming of law, the regulation, or there's no. It is, I think, an individual driven. Sir, what I would suggest is this. I think these are individual issues, sir, where, the law is very clear on this. RP is required to make all the compliances. And if you were the director, even if you're a suspended director, you can definitely ask questions. Ideally, it should have been raised during this time. I think it's very, I do not know why. Yeah.
So,
Yeah.
the company was handed over in running condition, okay, which was closed down.
So, Anup, this can be taken separately because
Let's take it separately. Let's take it
directors
separately.
are part of the COC. You can
Absolutely.
oversee. You are part of the management. You can sit in the office daily.
Mandatory participant in the COC.
First thing which was done was to, keep the directors out of the company.
Yeah.
That was the first decision.
Sir, I'll listen to you very carefully after this. But I wanted to thank. So there are so many professional and the lawyers and advisors. You can definitely discuss your fact situation.
Representing industry, that there is no talk of how to revive the industry. We are talking of recovery, and recovery is not the motto of the country. It's the revival of the industry should be the.
Absolutely.
That is where I'm coming from.
Thank you so much. I just wanted to thank Mr. Shukla for spending time today and sharing his insights. And I also thank the other eminent panelists. I know it's already time for lunch. I can see some plates. So people have already started taking lunch. So I just conclude this session. Best of luck to the next panelist. Thank you.
Thank you, everyone.
We'll all reassemble at 2:15 for our plenary too. Thank you. After that scrumptious meal, I'm sure it's difficult to stay awake, but let's open our senses and welcome for our second plenary session on pre-pack insolvency and cross-border insolvency mechanism. Ladies and gentlemen, please allow me to welcome Shri Sandeep Garg, Executive Director, Insolvency and Bankruptcy Board of India. We will have with us Ms. Misha, Partner, Shardul Amarchand Mangaldas & Co. Please join me in welcoming Mr. P. Ashok Kumar, Associate General Counsel, ArcelorMittal Nippon Steel Limited. We have with us Mr. Divyam Agarwal, Partner, Jyoti Sagar Associates. Mr. Prakhar Sharma, General Counsel, Kotak Investment Advisories Limited. Thank you all our esteemed panelists. Over to you, Misha. Thank you.
Thank you, CII, for this opportunity. I would like to thank especially IBBI and Mr. Garg to be here personally present. The whole idea of the panel discussion at an event like this is to bring out the issues that the different stakeholders in the insolvency resolution process and IBC processes generally are facing. And we are grateful for IBBI's representation here because we want to be heard and we want to be informed about the thinking and the direction in which the regulator is taking us. And we hope we can use this panel to bring out some of the issues which we as different stakeholders in the CIR process and liquidation and other solutions we are looking at under the IBC we have faced. I'm glad that we are a quite well-balanced panel, and I hope it will make fruitful discussions for all. And without taking much time, Mr. Garg, if I can request you for maybe opening remarks to set the stage for the discussions here.
Learned panelists on the dais, members of the distinguished audience, very good afternoon. I am very grateful for the opportunity being provided by CII to share my thoughts on pre-pack process. And I will take this opportunity to discuss its design, performance, and its potential, and which can form a base for further discussion by learned panelists. So basically, taking you to the background, COVID-19 pandemic had a significant impact on business and particularly on MSMEs, which faced severe financial stress. So this PPIRP framework was devised basically for the insolvency resolution of MSMEs. In the design, we thought that it is an efficient, flexible, and cost-effective process when compared to corporate insolvency resolution process, CIRP as we call it. So this process is quite different from normal CIRP in several design principles. So unlike CIRP, which can be initiated unilaterally by a creditor, this can be initiated after there is an agreement between the debtor and say 66% of unrelated financial creditors when they agree for initiation, and then the debtor can file the application for it. So though because pre-pack involves an element of agreement, but then this agreement is difficult to achieve, and as we will see later. So another significant difference has been that PPIRP follows a debtor in possession model compared to CIRP, where the resolution professional is in control and the COC is in total control of the both the business of the company. So though this debtor in possession model ensures that there is minimum disruption to the company's operations and there is a better cooperation between the parties, and also it mitigates the stigma associated with insolvency, but then it has its own challenges, as we will discuss. So the resolution process professional, he is responsible for driving the process, while the existing management of the corporate debtor is responsible for the business of the company. But it is easier said than done, because process involves finding out the correct value of the liabilities of the company, correct value of the assets of the company, and which are in the control of the existing management of the corporate debtor. So how do you do it? So the design involves basically submission of some preliminary information about the claims and the information memorandum, which basically takes the details of the assets of the company to be submitted to the resolution professional, which then can on that basis finalize the claims by a public invitation process and finalize the information memorandum if he seeks any further inputs from the company. So, and this has also been provided in the design that if any loss is suffered by any party because of faulty submission of information by the existing management, then that he has to make good the losses. Another design feature has been the concept of a base plan, which is not there in CIRP. It is very difficult for a party who is not conversant with the business to give an initial thought and initial plan. They are always in doubt how much value we should basically offer to this company. But if you have a base plan, you have a base. From that you can start. But then there is a information asymmetry. The person who is giving a base plan, the promoter who is giving a base plan, he is definitely in much better knowledge of the information, and he can give a plan of a lower value than actually the value of the assets are. So to ensure that the base plan is of a correct value, some of the incentives and disincentives have been created in the system in the PPIRP process. So basically, incentive was in the form that if you find that the plan is a good plan, it offers good value, then probably COC can directly adopt that plan if it is not giving any cuts to the haircuts to the operational creditors. But if they think that the plan is of not optimal value, then they can have a challenge process. And in the challenge process,
if some plans comes up which is much better than the resolution plan, the base plan offered by the existing management, then that plan can be directly adopted. Otherwise, you can ask the existing management to match the bid. So there are enough incentives in the system that you get a credible base plan. Because if somebody offers a significantly better plan, then probably you are out of the system and you can't even you can't even participate in the challenge. So these incentives were built into the PPIRP process. And while another thing which happens in the process is that since the control of the business is with the existing management, there is always a possibility that some assets may be stripped or there may be a gross mismanagement of the company. So to avoid such a situation, some powers have been given to the resolution professional to call for information from the existing management, to attend meetings of the management of the company, and also various important decisions can be taken about the business only with the approval of the creditors, with the approval of COC. And COC has been given the power to convert the process to CIRP. And also in cases of gross mismanagement, if A agrees, if the NCLT agrees, then in that case, control of the business can go to the RP and company can even be liquidated if the base plan has not succeeded in getting any other person. So we have built probably too many safeguards in the process. Probably that was a result of that distrust which was there between the debtors and the creditors, and probably that was flowing from the earlier insolvency regimes of SICA. So despite its potential benefits, and many benefits are there to existing management, that they can retain control over the business, they can basically run the business as they want so that it does not suffer, as has been somebody had raised in the previous session, that a business concern which was being run as a going concern was probably not did not remain a going concern because of some lapses of RP. So that's a good idea. But despite these potential benefits, PPIRP has not taken off. We all know that it has not taken off. There are only 4 cases which have been admitted so far. And if we introspect, actually we had done a roundtable on this. We had taken some bankers, we had taken people from banks who are dealing with these MSME businesses, etc., the branches of that. And so some of the reasons which we came to know through that roundtable was that basically, one is that this is narrow in scope. It applies only to MSMEs and corporate MSMEs to speak of. So, and during this period, there has been alternative liquidity support, and also they have so many restructuring schemes have also been offered by the RBI during this period, during this COVID period. So it is also one of the reasons which were cited as that it has not taken off. Then another major reason was cited was that there's a difficulty in achieving this agreement. The agreement has to be there between the debtor and 66% of the unrelated creditors. So in a case where lots of creditors are there, probably it is very difficult to achieve that agreement. There is no platform on which all of them come together and agree to agree for initiation of the CIRP. Besides, there are several informational requirements about giving a base plan, giving a preliminary claims list, giving preliminary information memorandum. Then there has to be a declaration about the avoidance transactions. So a lot of information needs to be given at the time of PPIRP. So any business which is not good at its record keeping will find it difficult to fulfill these requirements. So this has also been given as a reason for this not taking off. In foreign jurisdictions, Pre-pack basically formalizes the negotiations which take place between the debtor and the creditor, and then this process basically formalizes that negotiation. However, in India, bankers are slightly hesitant about negotiated settlements, and because of the potential accusations of favoritism. So, in the recent discussion paper which was issued in January 23, the suggestion is, the discussion paper says that we may apply it to probably a broader range of corporates, and also some procedural aspects are also intended to be relaxed. Let us see what comes out of it. So probably we may see a better adoption after these changes take place. Then paper also proposes a reform of the fast-track insolvency resolution process. This process basically provides the financial creditors an opportunity to initiate the process themselves without an agreement with the debtor and without the involvement of the adjudicating authority at the admission stage. So probably this process will be beneficial in cases, can be a potential use maybe in cases where already the creditors have taken possession of the assets or are in the management of the company. This may also be possible in cases where this process initiated quite early, in the sense that existing management of the debtor is still in a position to participate and they are not hit by 29A. Then probably they will have an incentive to participate in the process so that they can remain an eligible applicant, resolution applicant in the process. So the process which is being envisaged is that there will be a public invitation of claims and the plans, and the process will follow a market mechanism for selecting a plan. Promoters may be given an option to match the plan if their plan is credible. COC can then approve the best plan in its commercial wisdom. Plan may be submitted to the final approval of the AA for legal certainty, for its binding and clean slate nature. So this process is still under redesign. In fact, it is being conceptualized by a committee headed by our WTM all-time member Shri Sudhakar Shukla sir. It draws a lot of inspiration from this pre-pack process. A lot of processes are similar. And we are hopeful, very hopeful, that these frameworks providing alternatives to CIRP will be helpful in reducing delays and probably helpful in reducing the burden of the adjudicating authority. So I look forward to now a fruitful discussion on this topic from our learned panelists. Thank you so much.
Thank you, sir, for setting the stage for this discussion. It frankly makes my job so much easier as a moderator. You've raised the most fundamental issues which are relevant in a pre-pack, but in fact, it touches upon all the fundamental issues in any insolvency resolution process. Some of the issues such as information asymmetry, having the efficiency of time, and not losing value or not having the assets moving while we are trying to resolve an account. All of these are issues which we face in the corporate insolvency resolution process as well. But as Sir has rightly mentioned, the hallmark of a pre-pack has to be that it has to be more consensual, it has to be faster, and it has to be efficient. And as Mr. Garg rightly pointed out, there have just been 4 instances till now. Of course, there are business and legal reasons, perhaps, the design reasons, perhaps, as well as the business realities of the COVID times and, the whole atmosphere of ensuring that the measures were taken, that MSMEs are protected. So perhaps those are some of the reasons why it has not seen so much of use till now. But I would just go to the panelist members, each one of them, to just understand what are our impressions, that why has pre-packs not really taken off in India till now. So Prakhar, if I can request you for your views.
So I think, uh, firstly, I think one of the most important reasons why it has not been taken up, which Misha, you rightly pointed out, has been the COVID interference. And I think as and when now that the time has come up, we'll see more of the, pre-packs launching off in a successful manner. Having said that, we also need to look at some larger realities into what we have learned from the CIRP process till now, and that can be applicable on the pre-pack solutions per se. So, the very concept, as Mr. Garg just pointed out, is a debtor in possession first, and the asymmetry of information that is between the debtor and the lenders and creditors. So essentially, there is some degree of information, symmetry between the two parties involved. And that is where the role of, I believe, information utilities and early warning systems comes into picture. I think our government is actually pushing into digitalization and also artificial intelligence in a great way. And this is exactly the perfect forum in which we can actually utilize that to at least assess the early warning signals of stress, so that without any further ado or devaluation in the value of the entity, we can go ahead and find out some sort of a solution. So for example, there is a very important part that is played in the identification as well as the reporting of the stress in the system. The reason being, lenders who are already working in tandem for that particular entity would get to know this is the time that we need to swing into action. While implementing, that is also a very important part. We need to have something called, an independent credit evaluation of the entire plan, which is also a very important part for the success, because then it instills a lot of confidence among all these stakeholders. So if there are credit rating agencies who are actually assigning a higher rating, say for example an RP4 or a higher rating to the residual debt and all, there will be many takers, and the plan, which as it is has a limited marketability. In fact, that is the very reason why we are calling it a pre-pack, that it is not as widely marketed as a normal CIRP, that is where the confidence will get built up and people will pick up. One important aspect that I think both my colleagues Misha and Garg Saab also mentioned early is that MSME is this entire pre-pack is A, limited to MSMEs, and 2, only corporate MSMEs, which means that only the MSMEs which are registered under the MSME Act, which is, I believe, not more than 10 to 11% of the entire MSME universe in India, are the ones who may be benefited from this entire resolution. So the idea is to open it up for almost every entity, and that will actually increase the number of cases that are resolved under this entire scheme. The other part is, we also talked about how do we ensure that there is no distrust among the lenders and all. So yes, rightly so, it has been pointed out that many of the schemes don't actually launch because there is a disagreement between the lenders, and the intercreditor agreements and all, they don't get signed up. So the way that can be dealt, and this is only one of the ways, Misha, is that there has to be some degree of a drag. Say for example, if 66% of the lenders actually agree to a particular plan, it should be binding upon everyone. So that is the way in which we can actually move on with any particular arrangement between the lenders. Also, I think a lot has been talked about judicial intervention on this aspect, and judicial intervention should only and only be limited to some very identified grounds on which a challenge can be made. Otherwise, everything can be challenged and nothing will get actually moving. So there has to be certain ground rules on defining these are the only things which are challengeable, and beyond that, let's hold our peace.
Thank you so much, Prakhar. Like, this is the insight coming from a lender, and I can see these are quite. And you've raised so many issues, and have so many questions to ask further panelists. But Divyam, here the last point which Prakhar mentioned about incentivizing the right kind of a behavior, and you and me have seen how these processes have worked in the CIR process, and we want to make it efficient. And of course, this is in a scenario where I think, apart from the fact that we want it efficient, I think the very idea of a pre-pack is that it works on a good faith basis, where there is trust between the corporate debtor and the lenders in a case of a genuine business failure. While of course we need to have the safeguards against any misuse, but do you feel that in the design of the pre-packs till now, is there something which we can do, especially from judicial intervention perspective, to make it more efficient?
Good afternoon. I said good afternoon. Thank you. In fact, there is this in 19th century, there used to be, sorry, I'm digressing a bit, but in 19th century, there used to be industry workers who were made to work for an overnight shift. That shift used to be called as a graveyard shift. In today's time, post-lunch session is considered to be the graveyard shift. So, good afternoon once more. I'll try to keep it as small and quick as possible. So, Misha, you're absolutely right, and I agree with Mr. Garg as well as Mr. Sharma that currently the problem is multifold. Why this pre-pack, which was introduced around the COVID times, somehow it has, popularly become a vaccine that doesn't work. And the reason is the conflict of interest of sorts. So one conflict which is evident is that here you have to do a voluntary haircut. It's not a forced haircut upon you. I don't know how many, and I'll defer to Prakhar's experience on it, but how many financial creditors, how many institutions are likely to take a voluntary haircut? They also have their managements to be explained. Obviously, one possible way to deal with it is a good example which Prakhar gave, was to have an independent credit agency or an independent body driving the process on the side, giving a dispassionate parallel view. That's point number one. Second is, when you talk about multiple conflict interest, one needs to see ultimately, and that in fact comes from the very fundamentals of IBC, that you need to ensure that at the end of the process, the company continues as a going concern. For that, everybody needs to step up and take some or the other form of a haircut or some or the other form of concession. I remember there was this one UK case of Monarch Airlines. I don't know how many of have you heard about it, but at one given point of time in 2000s and 2010s, it was a major airlines of UK. They went through this pre-packaged plan, and in this pre-packaged plan, the company provided a similar base plan kind of a situation, which was ultimately rejected by the creditors because they were not getting enough meat from the entire scenario, resulted in the entire airlines going bust. So what we really need to come up and is to have a proper process which will ensure that there are checks and balances which are provided, while interest of every stakeholder must be honored and protected. It should ultimately yield in a benefit for the company. On the judicial scrutiny side, as you pointed out, we would require NCLTs and IBBIs to step in to ensure that they provide a thorough check. They see if things are not moving in the right direction, then they push forth what they believe is right for the company. Another thing they can achieve is, and though Prakhar alluded to, but I would like to stress on it more, that when you say 66% majority, why not in such situation when we know it is right now currently dealing with MSMEs, why not make it 51%? Why not bring the number a little down so that ultimately it's a majority view, but it's not forced to that extent that some players are able to play a more vital role as in comparison to others. So and I am all up for MSMEs. I would rather say that we time has come that, and this is what in fact the insolvency committee reform suggested, that this has been rolled out in a phased manner, and eventually it will be brought to use for other corporates as well. And I think time has come, then they should open it up for the corporate world as well. I have some thoughts there, but we'll keep it for the second topic.
Right. Thanks, Divyam. And, I'm excited to reach Ashok now, that Ashok represents, an interest which has seen the biggest case of insolvency resolution in India. And I'm sure you have a lot of insights. As I said, the fundamental challenges of any insolvency situation is the same. Whether it's Monarch Airlines or the Daewoo plant, which actually got, sold in scrap because of an inefficient liquidation process we had under the Companies Act. And it's with a lot of effort that all stakeholders here, be it government or this professionals like us or the stakeholders involved in a company, who have built a remedy which is definitely far better than what we had in Companies Act. But it's a time for us to move forward, and we need to make it more efficient. And of course, the intervening COVID and the and naturally, because there were a lot of unavoidable circumstances because of COVID, that there is a bit of a slag in the system now. Ashok, do you have any views about how we can, because you've actually seen and are continuing to experience the biggest, acquisition in India of the insolvency. What's the learning? How can we make it more efficient, especially for a more informal? Of course, you represented a more of a hostile takeover, if I can say, but we are looking at a consensual situation, perhaps, where the corporate borrower is actually cooperating with the lender. So do you have insights into how we can make it more efficient?
Audible. Good afternoon, everyone. So speaking as the last has its own advantages, so I can pick from whatever was already discussed, and most of the topic that I want to discuss was already touched upon. But as Misha suggested, as a person who has seen the biggest insolvency resolutions over a period of time since it's there, right? I my views on this pre-pack. So pre-pack definitely is a great way forward for sure, right? And as Mr. Garg also explained in simplest form, right? The regime as such has a lot of potential. But now I will begin with saying the advantages as I see from industry perspective in comparison with say ARP, right? I see this as an enabling resolution process, right? Why I say that, unlike in this ARP, so here the corporate debtor, the promoters, the management, they get to control the asset, right? So this is a fundamental shift, right? So here the acrimonious never-ending litigation which you have referred to, so those kind of litigations are totally avoided, right? And the role of NCLT and the courts are minimalized, and we all know how stressed they are, right? So that is the second biggest advantage I see. And the leakage of assets or the stripping down of the value of the asset during this ARP period, that's again one of the biggest issue in this ARP process, right? So we need not get into the debate of whether it's happening or not, but at least there are allegations for sure, right? So this pre-pack is the way forward. And whether this pre-pack is working very well now, and I doubt, and we all agree that there are not many takers as of now, because it's fundamentally it's only for MSME now. Any system will be as good as its people, right? So here again, right? So when it is restricted to only to MSME, as my panelist also mentioned about what is the percentage of MSME within the universe which is registered, which will fall strictly within the definition of MSME. So there again is a challenge. And again, within that small minuscule percentage, the awareness, their access is a challenge, right? The present CARP system, it is successful for sure. But why it is successful? because of the ecosystem, the movers and shakers of this particular ecosystem, including the top lawyers and law firms, including the top professional accounting firms, which have become insolvency firms as well, right? Including the banks and lenders, where the topmost people are involved in large insolvencies, right? Whereas in MSMEs, who will get involved? What is the motivation for these people to get involved? So that raises a larger question, right? So the access and approach available to MSMEs for this ecosystem is a challenge that needs to be changed. That will change when we widen the pool, when we don't restrict to only to MSMEs, right? And as other point with respect to lenders' reluctance, right? Naturally, that is a major point. Again, within lenders, the level of the officials who will be deciding an MSME resolution plan will be different from the level at which a large resolution plan will be decided. So the involvement of the senior-most officials of the banks or lenders, they will have a larger risk appetite, they will be able to take the calls, but may not be at this level, right? So that has to change. Overall, this is definitely the way forward. Pre-pack we have to have for large corporates, industry players like us who can be the potential resolution applicants for appropriate assets. We definitely look forward. So I would request all the stakeholders and the concerned committee to look into it. Of course, we will cover in the subsequent round. Yeah.
No, thank you, Ashok. And in fact, earlier the point was made during the discussions, and Mr. Garg also mentioned, I think there is a lot of need for the confidence building in terms of different stakeholders, to enable different stakeholders to come together and remove that acrimonious quotation, that angle from the whole aspect. Of course, that will make lawyers like me less busy, and I'm happy with that, because at the end of the day, our IBC needs to succeed, because the delays in the system, and the more you litigate, unfortunately there are consequences of delay which leads to leakage of value, and we've seen that, and we've suffered in the process. But one thing I really felt that we need to, maybe for pre-packs to work out, is to create that platform where everybody can come together, and a platform which has a character of an institutional platform, which can be driven by professionals. As Ashok said, any system as good as its people, and as professionals, as stakeholders, we're all responsible collectively to make this work. And my limited experience in IBC till now is this, that we are relying on NCLT to be the platform to bring us all together. But those are courts, those decides disputes. And and insolvency is that part of dispute resolution practice which is not acrimonious. And I think this is something which culturally in India is so different from how in developed jurisdictions insolvency resolution is approached. So I think there needs to be a mindset change, and that mindset change will come when there's enough confidence for each stakeholder to be able to take their decisions, and there are no questions asked without understanding the differentiation in the facts. And the law is not dictated because one bad apple has brought bad name to the entire ideology behind the law. So from keeping all that in mind, one of the things I think which the panel seems to be having a consensus on is that we need to expand its scope for sure, not limited to MSME, bring it to big corporates. But we need to be mindful that big corporates and larger companies will have more complicated issues. And we need to have a system which is actually efficient and can do that confidence building. So are they, of course we've spoken about, and Prakhar, you've already given certain, suggestions around this, but is there anything else? Because from what I hear each one of you, I think there is a need, as we also spoke about awareness and access. So there's a need for that advocacy and that spread of awareness. One of the directions we are headed in terms of trying to find solutions is to go into fast track insolvency resolution. We do have it under IBC, but that's right now only limited to very, very small companies. But I think what the MCA is talking about and IBBI is thinking about is expanding the scope and making it fast track. One of the things which comes to my mind is that we always have already have CIR process, we have pre-pack process, we are looking at making it more efficient, then we have fast track. Now we already have some 3-4 routes under the insolvency law, and I'll be very honest here, I've seen how things are argued in a courtroom, and there is ample scope of confusion already. And if you have 4, 5, 6 routes introduced more, is this a recipe for even more confusion and more litigation? Or is there a way of us, because the principles of the design of IBC, whether it's for pre-pack or CRP, is some of the basic things: balancing the interest of all stakeholders, bringing efficiency in the system. And we are aware of the fact that there is information asymmetry and there are conflicting interests. So the question which I want to ask each of our panelists is this: are we, in trying to find the solutions, bringing out too many models within the IBC and causing more confusion than helping it? Or can we work on maybe simplifying pre-packs and then allow it to be adopted for all?
So, Misha, there's actually a very interesting question. And I'll go from the start when you actually mentioned that, look, there has to be a change in the mindset. And like in the developed economies, insolvency as such is not a taboo. Business failure again is not a taboo. People keep on doing with their entrepreneurial skills. They keep on building new businesses. Business failures are taken just in the stride. They move on, file insolvency. Once it is done and dusted, they come up with few fresh ideas. So I think that particular mindset is still not reached to all the levels out in India. That part has to come up. But I believe with the new push onto startups and the way the newer generation is looking at businesses, I think that mindset is not exactly very far away. Now, coming to the other aspect, which is a very interesting part, with multiple forums and multiple tracks, is it like we are complicating the issue or we are trying to simplify it? So here I would like to draw some parallels from our usual way of litigation. So there is arbitration, so there are court cases, right? In that also you have fast tracks and there are the usual courts. Then there is also an insistence, and in fact it has become now compulsory to go in for a conciliation before an arbitration. So what exactly does that indicate? The idea is to declog the courts as much as possible. I believe the intention here, the legislative intent is basically to reduce the number of conflicts that are reaching and the ease of, ensuring that all the resolutions are done quickly. Having said that, I think these are, steps like scenario. So first we need to explore something which can be resolved quickly through pre-pack solutions. And to that excellent idea, what you just mentioned is, let us now enlarge the scope of pre-packs, try to make it as smooth and efficient as possible. And to that extent, we may be able to filter out or weed out many other resolutions at the first stage. If by any reason things don't fructify at that stage, then we go on to the next stage of maybe CIRP or liquidation or other things. I think that is the only way that we can look at and address issues.
Thank you. I'm conscious of the time, but and I would want IBBI, the regulator, to have the last word. So very quickly, Divyam, your response on this. And
yeah, so I agree, Misha. Problem of plenty is there, but let's just divide it in two aspects. One are complex matters, as Ashok pointed out, complex litigation, large matters. I personally feel pre-pack is not meant for them. You cannot, I mean, we have done those cases where complex issues were involved. In fact, in a pre-pack case, UK had House of Fraser, which is a very well-known departmental store brand. They had a pre-pack. It failed because of the complexity and the nature of shareholding and the business structure. So let's keep those complex issues aside. For the rest, let's just try to analyze how they are, how a pre-pack would be relevant. Let's, as Prakar said, conciliation before arbitration. Now, we know the numbers, almost 40 to 50% of IBC cases, they are getting settled prior to the appointment of COC. I remember Nirmala Sitharaman pointing it out somewhere that around 20,000 cases were settled with the fear the management had that they're likely to lose the management. So if a management is given an option that instead of going through this dirty procedure of where you have been dragged, then you to take back the control, you decide, why not come to a conciliatory stage beforehand, try to put together a plan, try to resolve it and settle it out without going into that issue. That's point one. Second is about business continuity. Lot of corporate debtors would love to have business continuity. CIRP results in ouster of the management. If a corporate debtor, maybe a small corporate debtor, if it's given an opportunity that, listen, you have an option of a pre-pack, why not continue the business as it is and ensure simultaneously that the company continues as a going concern, maintain the interest of the shareholders, creditors and everyone. So in order to maintain that business continuity, a lot of times they will try to pick that as an option. But yes, there is a problem of plenty. There is schemes of arrangement. There are multiple things happening around. So it may, if not used efficiently, and if not put a proper plan is not put in process, it will be again lost in the total number of issues involved.
We would have to write memos as to why we are doing one and not another. And we are aware of at which all levels we have to do those memos. But, sorry. Right, sir. Sure.
Now, we are talking of actually recovery. We are not going to the core issues of looking at why the industry goes sick. Okay. That is one thing where one has to go. And it's difficult for the lenders also when they take haircut. In many companies, the lenders can look at option of going in for equity and employing a person of that field or even their retired person to be put on board so that the company can run. So let them acquire equity, and when things go right, they can sell equity and that they can come out. That is one solution. Secondly, the personal guarantees. What happens is, in many cases, an entrepreneur may be tempted because his personal guarantees involved. The fear of failure may result in draining of money from the system. So that should be avoided, and that can be avoided by introducing a system. I suggest that instead of having personal guarantees of the entrepreneurs, a insurance product should be introduced, whereas the company gives premium every year for the insurance. There are 6 crore SME sectors. Everyone will not go for it. So if you, instead of, it's something which is not coming. So if you take the insurance product and from 6 crore industry, you take premium for against the personal guarantees, then even if you go bad, the insurance company will still make a lot of money, and the entrepreneur will also be having a peace of mind that he has done something for the country and he is not coming on road in case of failure.
Absolutely. That's something which I feel are of course, we are talking about genuine business failures, and these are some of the mitigating factors which can be as a complete ecosystem in the economy we need to develop. And I think those are wonderful issues, and I'm sure the regulator and the government would also, you should be promoting this, and we as a body should be advocating these solutions. Coming back,
Madam, in continuation to this, I just wanted to know what kind of representation you have from the industry in IBBI, roundtable or advisory committee or consultancy. What kind of
So I would.
So basically, we have two advisory councils. One is for the insolvency professionals, and another is for processes. So Mr. Kotak is the chairperson of the the advisory committee on processes, and we have many industry representatives in that. So in both industry representatives, creditor side, professionals, academicians, all of them are there. In fact, Mr. Uday Kotak is the chairperson. So it is well represented. That's what I can say.
I'm conscious of the time, so Ashok, I would want some of your, concluding remarks, and then I'll go to Mr. Garg because of course, as regulator, we want to have the first and the last word and the direction in which we should be headed after this.
Yeah, so before we get for the concluding remarks from sir, so I will give some more insights with respect to the views on the various modes of resolution, right? I don't think we have one size fits all kind of scenario, right? So we need to have various options for sure. We have MSMEs kind of scenarios, we have large corporates, we have various industries, the insurance, finance, these kind of industries has to be looked up differently. So I'm sure we need to have various models. And at the same time, the other question was whether we should make it watertight, we should make it better, then roll it out. I don't think that way, right? Because we have to start somewhere. The system will correct itself, right? We have seen how IBC has evolved. And if that was the case, we would have never seen GST, for example, right? So we have to start, and already it's delayed, I feel, as far as pre-pack is concerned. So it's better to begin, and if there is, of course, there will be a lot of improvisations required. The courts will make it more better. In IBC, even now, there are judgments. Despite the law being clear, we face a lot of hurdles, lot of challenges. Practically, even the courts, the authorities, government machineries, they don't recognize certain aspects which are already clarified by courts or already which are there in the IBC, right? So these issues will be there. We have to live with it, and it will be progressively going towards a better process for sure. Yeah. Thanks.
Thank you, Ashok. And I would just conclude with one, request for IBBI perhaps to consider. And once again, I'm advocating against myself, which is exclusion of NCLT in the pre-packs. But one of the suggestions which was on the table earlier as well, and I would just want to raise it here, that admission of a pre-pack, because pre-pack solution is actually something which is more consensual for a genuine business failure. For a genuine business promoter coming together with its lenders and finding a solution. And inherent in it is the trust. And one of the suggestions that we've been toying with is why can't we, instead of going with an application which has to be admitted by the NCLT, why don't we simply, once there is a requisite consent of, and I will not get into, whether it's 51% or 66%, it will take some time in delving into that. But whatever requisite percentage of creditors have to agree with the company before triggering pre-packs, why can't they, after doing the base minimum documentation around this, file a declaration with the NCLT, say that we will trigger this process, start and appoint an insolvency resolution person to put together information, agree to advertise the opportunity for a pre-pack in whichever limited fashion or expanded fashion the lenders and the company has agreed to rescue it from the genuine business failure, and say within 30 days or 15 days or 45 days, whatever number of days we agree, nobody goes ahead and files an objection in the NCLT after this has been publicly put into notice in the public, and we can discuss the modes of those public notice. Then at least the process starts within 30 days, 45 days, and NCLT is not sitting and checking whether actually that requisite percentage of creditors have voted in favor of it or not. At least take that thing out so that the process can get started. If anybody has a problem, if there is a bad apple and somebody is hoodwinking the creditors, that creditor will come forward and object to NCLT, and NCLT can then look at it. So at least entry should not be again waiting for a nod from NCLT. So these were some of the suggestions we had, which we wanted IBBI to consider. And so anything else in terms of whatever has been the discussions, if you would want to sum up and conclude the panel with.
So excellent suggestion. In fact, we are thinking in respect of fast track insolvency resolution process in those terms only, that probably admission would not be required at NCLT. Process will be initiated by, say, creditors, a significant percentage of creditors, say 51% of creditors, and that too, like creditors which are regulated entities, like maybe scheduled commercial banks who don't misutilize the process. So they can initiate the process out of court. Of course, the corporate debtor will have a opportunity that if he doesn't agree with the initiation of the process, he can go to NCLT. Opposing that process, he can go. But we're thinking of a process where the process will start, and it's probably if something comes up like that, probably we can do it for pre-pack as well. Here, in fact, in pre-pack it would be even easier, because here there is an agreement between the two parties. So probably admission, we don't need to wait for the nod from the court. So that can always be done. So coming back to what has been supposed is whether we will be having too many processes. So probably not. And I agree with him that we should experiment, and probably experimentation leads to better design of the systems. Experiment, but be very flexible. If something is not working, probably just try to rectify it or try to withdraw. Be flexible in that, but experiment. When this IBC was initiated, at that point of time, we did not have any cadre of insolvency professionals. But then again, we were able to build a cadre of insolvency professionals because something was to be implemented. 12 big cases, etc. were given, and that probably got the momentum, and we were able to build a cadre of insolvency professionals in a very, very short time. And that is how things developed. So probably experimentation, and especially in the current business scenario wherein things are moving so fast, both on the technology front and business model front, a good law has to be also very flexible in the sense, and law by its very nature will not be able to keep pace with the business, but at least it can try to. So my opinion, let us have more processes which deal with various kinds of situations. So pre-pack is a kind of a situation where there is an agreement between the two parties, and probably it's a good process for that. It allows for business continuity. It allows for things to smoothly transition. Something was said earlier, I'll come back to that basically. So how to achieve an agreement and what should be the role of IU? This was said by Prakhar. So he said basically, so IU at present also is a repository of all the debt and default records. So information utility gets all the debt, and whenever somebody informs information utility of a default, that the default has been committed, it communicates that default to all the creditors of that company. So we were looking into it for designing a system wherein we were trying to find out how that 51% agreement will be achieved at. So this is a good system wherein just after the default, somebody can find out who the creditors are and can then try to have an agreement between the two. So another problem was mentioned, that how do you decide about the haircut? How do you pre-decide about what haircut is to be taken? So probably that's not a problem. We have a concept of valuation here. So liquidation value is available, fair value is available, even though these are only estimates and they can go wrong at times. But then there is something indicative available there. And also, if the creditor, in the creditor's opinion, this plan is not offering proper value, they can always try it in the market. But the market mechanism is always available. So probably finding how much haircut can be there in the system may not be that difficult thing. Probably the roadblock which we are facing is that we are not able to get that agreement, that 66% agreement that has to happen before for starting the insolvency. That appears to be the major problem. And also probably the record keeping of our MSMEs is not so good, that they are able to submit all these documents, information memorandum, and then declaration of avoidance transactions, and then list of claims, etc., so that the process can offtake in a fast manner. So those are my thoughts. I think if we have sufficient alternatives, and if we start the process early, which we are trying both in case of pre-pack and also in case of fast-track insolvency resolution process, then probably the existing management will have a chance to retain the business, to continue with the business, and if they give a credible plan, then probably they will be able to retain that business. They will not be hit by Section 29A, because Section 29A, the most common ineligibility is the NPA declaration. Not so many other eligibilities which are visited upon. It's basically the NPA. So somebody is eligible till 15 months from default. That is 12 months from NPA. NPA is after 90 days. So if we come in the system early, probably there will be enough incentives for one to resolve it. And if we detect the stress early, then probably it will be good for the economy as a whole as well. Thank you so much. Yeah.
Thank you, sir, and thank you all the panelists. I think we are set to allow the next panel to start, and thank you audience for everything, unless anyone has any question or comment to be made.
If anyone has any questions on this, welcome. Probably we have time or we don't have time.
So questions need to be answered even if there are no.
Sorry,
no time
I have one question.
Yeah, probably.
This withdrawal under 12A, since it is, and after having OTS settlement with banks, this is not being considered as a resolution in NCLT, okay, and not having a clean slate status. So can this be looked into?
Probably not, because the clean slate principle is available to the new management. So there are apprehensions that persons may try to take advantage of it for maybe tax avoidance or probably avoiding other criminal liabilities. Probably at some point of time we may consider it, we may examine it. If not consider it, we may examine it.
Sir, the issue is this can be verified so that if nothing is wrong, and a case-to-case basis, if this can be seen, then it will help. I said in my case, I'm saddled with cases which are not attributed to me. After having withdrawal under 12A.
So this appears to be one peculiar situation wherein the professional has not done his job well. This appears to be a situation like that. So we have not noted many cases of this type. So if too many cases of this type come up, then probably we need to think of an intervention. Otherwise, No, so on the case-to-case basis, if you have a good case against the resolution professional, you should go ahead. Should file a case against him.
So there's a formal procedure under the IBC, and IBBI has the whole process. So that can be adopted for those cases.
Okay.
Thank you, esteemed panel members. We would now like to begin with the last session of our day on stressed assets as new investment avenues. For our last plenary session, I would like to call upon stage Mr. Rajesh Sampson, Partner, Deloitte India. Welcome, Mr. Rajesh. Ms. Veena Shiva Ramakrishnan, Partner, Shardul Amarchal Mangaldas and Company. Mr. Prashant Venkatesh, Credit Structure and Managing Director, Broad Peak Investments. Ms. Mani Gupta, Partner, Sarthak Advocates and Solicitors. Mr. Praveen Bhaskaran, General Manager, Stressed Assets Unit, Power Finance Corporation Limited. I extend a very warm welcome to all our panelists. Looking forward for a fruitful session. Over to you, Mr. Rajesh.
Hi, good evening, everyone. Apologies, folks, we'll give it 2 minutes. Good evening, everyone, and thank you so much for joining us for the last session today. So we are in the graveyard shift. It's always the most challenging one. I guess the topic of our discussion is on stressed assets, new investment avenues. And before anybody falls off to sleep hearing that, the funny thing is I've been hearing this title for the last 5 years. I've been hearing it from the early days of the code. I'm hearing it now. And somehow the figure that has always stuck in my mind over the last 5 years is $200 billion, as I think my fellow panelists know very well. $200 billion. That's the number that we've been quoting in all these forums. 4 years ago, when I think all of us did our road shows along with the IBBI to overseas destinations to look at investors from across the globe, I think the way we always talked about it was $200 billion. That's the size of our investment pool. I really hope that the panel today will help me challenge that number, and let's just understand how much of that $200 billion has actually happened, how much of it will happen, and how will it happen. So I thought I'd like to actually tell all of us a little bit about the guys who are on the dais with me, starting with Praveen on my extreme left. Praveen is actually with the Power Finance Corporation. And today, I think Praveen has a fairly unique position, I would say, in the stressed assets economy, because he's long been a lender. For several years, he's been a lender with a bunch of bad assets. I'm sorry, Praveen. But I think over the last 1 year or so, he is also a resolution applicant in his own sector, which is really unusual. And I want to understand from Praveen, is this the way that we're going to go for some sectors, in future? Veena is from Shardul Amarchand. I think she is an expert on a whole bunch of areas of stress resolution outside the insolvency process. And this is something which is very close to my heart, because I have a theory about where the market will be over the next 2 or 3 years. And I'm very keen to understand, Veena, if that's your theory as well. And what do we see going forward after so much noise about the code? Is our next phase going to be a bunch of noise about things outside the code? Mani from Sarthak, again a legal expert on various aspects of the insolvency process and the law. I'm very keen to understand from her, what does she think is going to happen to our law going forward, and how much of that is actually going to help us over the next few years. And I think Mani has something that I'm very keen on understanding, which is that she gets to see life from the point of view of many, many stakeholders in the insolvency process, other than the ones that we always read about in the papers, which is the lenders. And she gets to see the whole process and feel the pain of many creditors other than financial creditors, in addition to the financial creditors. I'm very keen to hear her points of view. And Prashant, welcome Prashant. In fact, welcome to India. So Prashant is with Broad Peak. So he sees the investor's point of view. And Prashant and Broadpeak are actually invested in our markets, which is fantastic. What's even more interesting is that they intend to invest a lot more. And I also assume that Prashant is not out of his mind. Certainly his LPs don't think he is. Very, very keen to hear what Prashant has to say about the markets going forward. This is such a huge topic, right? And it's a topic that we've talked about ad nauseum for the last 5 years. And I think what we decided as a panel is let's kind of split it up into its basics. What's a deal cycle? What is an investment in stressed asset cycle like? There is your position of entry. Somebody like a Prashant comes in, makes an investment, maybe takes somebody out, right? There is an exit. Somebody like a Praveen has resolved an asset as a resolution applicant. Someday he's going to have to get out of it, or does he, right? And then there is a process in between. And there are all kinds of complications in the process in between where money and Veena, I suppose, help all of us. So I thought we'd split it up into those three buckets. Yeah. And I'd like to talk a little bit about starting with the entry, right? How do investors actually come into our sort of stress assets market, and how is the whole experience? So can't think of a better way to start this off than by asking you, Prashant. Why are you here? I know why you're here, because you want to be part of our panel. But why are you investors here? 5 years down the line, with so many things that have gone, so much water under the bridge, right? What do you see today? And what's so exciting about India today?
Thanks very much, Rajesh. So we're a 15 or 16-year organization, and we came into India on the credit side. Obviously, we have an equity business as well, and that business has been investing in large cap equity on the exchanges. We buy, we sell, and we move on. But we went into credit investment in India only in 2016, 2017. Obviously entirely because of the Insolvency and the Bankruptcy Code. Why not before that? Pretty simple answer. We thought that the process to recover money in India was itself the punishment. You didn't need to do anything more. It was a very, very tortuous, long process. I remember starting my career out as a litigator and attending BIFR meetings. And the person who I replaced, he had been attending those same BIFR meetings in respect of a textile mill in Chennai for over 20 years. Nothing really happened. But as time went on, life sorted itself out, and it had nothing to do with the BIFR or the AIF or the SICA or anything of that sort. That mill was sitting on prime land in Chennai, in Poraswakam area, which became very, very valuable. So the company actually came out of its process. It doesn't make any textile mills anymore. It is a real estate developer, and it has sold that land, and everybody is happy. But that was just a function of luck. The process did not guarantee you that outcome, and I think that was the reason why we sat out previously. The change that has happened because of the IBC is, yes, we've crunched the time, and I'm sure I'll tell you that that's still a problem, but let's leave that for the time being. It is a huge improvement from where it used to be before. So therefore, that is a very significant change that's happened. But I think the second and the more critical thing that has happened is that now borrowers do realize that they need to repay the loans. Companies understand the fact, and management and promoters understand the fact, that if they were to mess around too much and an IBC is pulled on them, more so because of 29A, there is no way back into the company. You lost management control, and more importantly, you can't go back and bid through some other mechanism. I'm sure people do it, but theoretically, that is a very, very important change that's happened. So those are the two critical things that meant that we were very keen to get into the insolvency processes and start investing and using our own international experiences and seeing what we could make of parallels in India. That experience has been good, but that cycle has kind of ended now. When a new legislation comes into being, especially when it is an insolvency legislation, you don't find that foundation, you don't find that time of stability in like the first 5-7 years. Principles are being set up. I mean, the Supreme Court has intervened so many times, but those principles are now coming into fruition. So to that extent, this first phase, I would say, has generally been successful. We can still argue about should it take so long to resolve a process, but what it has done is change mindset and crunch times in however limited a way it has. So to that extent, we think, and the most important thing on top of all of this, the size of the opportunity. Put that together, I think it's still a very, very compelling case. That's why I'm in India. And I don't have any problems if people think I'm mad, so long as they give me the money. But I'm hoping my LPs don't think I'm that either. So let's see how it plays out.
So you're still excited?
Very excited.
Right. And the jury's out on whether you're out of your mind or not.
Fair enough.
Okay. Fantastic. Okay.
We'll talk about that 7 years from now.
We'll see. Praveen, so you're the odd man out. You're the odd man out today because my guess is that there is nobody in the audience who has a role similar to Praveen's today. I can probably bet you that. Because you're a lender.
True.
You have been a lender and you're a resolution applicant in one of, and this is a sector which is very close to my heart, right, which is the power sector, right? And I am a great believer in thermal power. Sorry to your LPs. I'm a great believer in thermal power. I'm a great believer in thermal power for this country, right? So I have for you, Praveen, just one question. Why? Why are you doing this?
Rajesh, you are a consultant, so you have all your freedom to ask questions.
Sorry, M&A advisor, but it's not the same thing.
But unlike the panelist here, the thing about me is I am here for the money that I have already invested in. And it's like 30,000 crores in all, together with my REC subsidiary. So effectively, the role that I'm playing is totally different. And the way that we are going about resolving the assets, getting our recovery done, it is all case specific primarily, because whatever we do in this sector, every project that we handle, primarily because it's all in the power sector, but each case is unique in its all respects. So in some processes, we involve Rajesh also. So because we are looking at a kind of resolution that is unique to the requirement of the project. And if you look at the projects also, it is quite democratic. But for the gas-based assets, which are all into stress right now, it could be transmission asset. And it could very well be a thermal asset, which he's quite harping on, but it could even be a renewable energy asset. So there is nothing like a specific thermal power asset which has gone into stress or something like that, but it is like quite democratic in the sense that all are equally susceptible to stress. So everything has to be dealt different. And what we have realized is IBC is a godsend, true, but there are each case has its own set of solutions. It need not be IBC for like a solution for all. There has been specific cases wherein we realize value through our one-time settlements also. And there are cases where we believe it is best realized if we continue with the existing promoters. So each case is a case in itself, and we are going through as it is. And recently we have also gone into a new field altogether, wherein we ourselves are becoming the resolution applicants. And that is happening because we are realizing the constraints in the sector. The issues that are flagging us in the power sector as such are quite unique. The number of bidders are limited. The kind of numbers that we realize are like more near to the liquidation values. So we have a fair understanding about our projects, and unlike other sectors, we believe that a better value could be realized if we ourselves can get involved in the process. So that is how we are going about doing it.
Thanks. I think just for people who may not be aware, PFC is obviously, I think the largest lender. Would be the largest lender in India to the IPP segment, right, in the thermal asset space.
We have like 8 lakh crores of assets.
Yeah,
and of that, like 30,000 crores, say like 4% is in stress.
Yeah.
And if we look at the provisioning also, it's like just 1% net NPA.
Yeah. And they've actually made history because I think this will be the first thermal asset. Lanka Amarkantak, it's all available in the public domain. Would encourage anybody who's not familiar to read up on it, where the lenders to the asset are themselves a resolution applicant. And obviously, I think we're seeing, one of the things that we are seeing in India is there are a lot of situations, and especially in power, it has happened where, state-owned entities are resolution applicants for projects. They're actually the best offerers for these assets, which is quite interesting. Praveen, I'm terribly tempted to to ask you a question about crowding out the private sector, but I won't because I think this is being recorded. So, but thanks for your comments. And Veena, I know that we have a slightly different point of view on one aspect. What's going to happen next? Linked to what Prashant said as well. We've had a lot of excitement around the code. There's been many processes that have started. There's been a few that have finished. There's been a few that have ended, with very happy results to the lenders. There's been quite a few that have concluded with people coming out of the rooms with pretty long faces. A lot of what had to happen actually has happened, perhaps. And a lot that is yet to happen is a bit more difficult. But I guess you feel that there is a significant portion of our $200 billion that will actually get settled outside the courts. Your thoughts, please.
Thanks, Rajesh. I think one of the things that will happen significantly is why will people choose IBC? Given that now we have seen the success of IBC, we have seen what is it that in IBC does not work. My view is that the key advantage is the clean slate principle. So the action that we see or the interest that we see in cases which are trying to get resolved outside of IBC is where the need for a clean slate principle does not exist. So if you have a resolution applicant or a white knight who is coming in, who either knows the promoter because they have lent to or they have been in the sector or they are aware, as long as the clean slate principle is not a criteria, I think most of the resolutions will move to outside IBC. It may not happen in the next couple of years, it may not happen in the next 3 years, but at least after that, especially given the timelines and given the uncertainty factor which is linked with the IBC, and if that continues, I think most of the interest will then shift to outside IBC for cases for which clean slate is not a requirement at all. I also think that distressed debt funds and ARCs will play a significant role in how active or how successful this story becomes. NARCL has come. Everybody has, I'm sure in this room, if we ask for views on NARCL, will probably be a 50-50 crowd. So despite those changes, despite those challenges, I still think that ARCs as a body will play a significant role in actually seeing how successful outside IBC resolutions would be.
Okay, I was actually going to put you on a spot by asking how is this going to happen. So what do you see happening? So you see a lot of asset reconstruction company deals over the next couple of years?
Couple of years is a short time, but in the next 4 to 5 years, yes.
And settlements?
3 to 5 years.
You think a lot of settlements will happen?
If RBI actually changes the most recent law that they made for ARCs, where a one-time settlement can be done, the language of the circular says after all the avenues for recovery have been explored. Nobody knows, no lawyer knows what all means. Nobody knows what is explored because there are so many ways in which you can actually resolve an asset. I do understand that ARCs have approached the RBI. If that changes, then I think there is significant scope for ARC settlements.
Okay, and a lot of people will also sell down to Prashant.
I don't think that opportunity will come because Prashant will be there in the front to participate in it itself. So, yeah.
Okay, and Mani, the whole presumption here, the whole presumption around resolving a stressed asset is that somebody essentially is selling out in some form or fashion. It's a settlement. He's effectively selling out to somebody, right? It's a debt which is being downsold to an asset reconstruction company. He's still selling to somebody.
Yeah.
It's a resolution process. Effectively, you're still selling to somebody, right? I'm just wondering, what's your view on the major impediments that you actually see in sort of all the options that we have? What are the major impediments for a new investor to come in to replace an old investor? And I'm just using the word investor very loosely, of course. And if you're okay, you can list about 21 of them, 21 impediments. And if you don't have 21, then 2 or 3 will do.
Okay, since we have only 44 minutes left, I'm going to try my best to list out 21 impediments. But I prepared for a substantially shorter list. Okay, so I think that within the IBC system, the impediments I'm going to talk about are all existing within the IBC system, but some exist only outside the IBC system, right? The first is, just 1 second. Sorry, I need to answer this question. Yeah, so I think the first impediment is the mixed signaling by government, okay? In the IBC process, we've had the government take a very proactive stance in the last 6 or 7 years where, legislative changes have been brought about, regulatory changes have been brought about to address market needs. But at the same point of time, you also have situations like what has now been created by Rainbow Papers, where suddenly I'm told that, if a statutory due is secured, is treated as a secured creditor, then a lot of resolution applications, resolution plans that are pending for approval could be tossed aside simply because they don't comply with this now latest judgment of the Supreme Court. So this kind of mixed signaling needs to stop from the government. That's the first priority. The second issue or impediment is one of information asymmetry. And this could arise both within the IBC process and outside the IBC process, right? And who's really responsible for this? I see 2 sets of people responsible for this. One is promoters. And second is, I'm sorry, I'm in a room full of RPs, but I'm going to say it, the resolution professionals. Okay? I know that...
Can all the RPs put up their hands, please?
Yeah, okay, sure. Rajesh wants all RPs to put up their hands. How many are in this room? I just need to see how many people I need to protect myself from. Thank you. No, I know that, since morning, I know that there's been a lot of bashing of the RPs, and I don't want to take away more time from my other panelists. But I will say one thing, right? You can't adopt a one-size-fits-all kind of approach. Yet, at the same point in time, I'm fully aware of the fact that once you're, when you're appointed, if the promoter is not cooperating with you to give you timely, accurate, and the quantum of information necessary for a investor to make the investment, your hands are also tied. But what I would say is that, please don't think that it's possible for anybody to do a due diligence on a power plant by visiting it for 1 hour in 1 week, no matter where it's located. You need to be more dynamic in your approach. And I think that in the morning, in the opening session, this was talked about, that there is a diffidence in the market, right? And there's a diffidence amongst our professionals which needs to be shed. We need to shed it now, and we need to be proactive. The third impediment that I want to talk about, and which I think is now largely we're coming out of that phase, and thanks to the IBC, is that banks and financial institutions need to have rational policies for deciding when to intervene in saving a stressed asset. And I think the example of PFC, the very dynamic role that is now taking up in the market, in the power sector, is a very good indication of that, right? One suggestion that I have for policy makers or whoever is responsible for this aspect is that, especially when you are dealing with a public sector bank or a financial institution, they will be able to shed their diffidence and take more rational economic decisions only and once they're pretty sure that they're not going to be prosecuted for a good economic decision. And we need to protect them from that aspect. So I can only list 3. The rest of the panelists will add 18.
Sure. And a point taken, because we don't want to see Praveen going to prison, not in the immediate future at least. Prashant, 5 seconds. You got to answer a question for me in 5 seconds. Does it make sense to invest in India compared to overseas markets? Are we better? Are we worse? How do we rank? Your 5 seconds are up. 3, to...
Yes.
Yes. It makes sense.
It makes sense.
Okay, thank you. Just at this stage, I'm very curious. Anybody has anything that they'd like to ask of our panelists so far? Any points that you want to raise? Any RPs who want to defend themselves? Anything at all?
And the thing I would like to add is there a better time? Because, see, it is all about a cycle. Every sector is going through a cycle. If you are looking at power sector today, it is that the cycle is showing an upward sign. So that is the reason there is so much of interest in stress.
You got to speak into the mic.
Yeah, sorry. So, all right. So whether it be hospitality, whether it be reality, as and when there is an upcycle, obviously there is a lot more interest coming into these sectors, and then there is a realization that okay, that cycle has already passed, or you are like at the hard end wherein you have to put in more in terms of valuation. So there comes the issue about attractiveness. So it's just not the valuation alone, but the timing of it.
So, Praveen, you've used my favorite, or rather least favorite word, which is very specific to India: valuation. Liquidation value. Very, very unique to our Indian legislation. When I work with buyers, it comes in our way. When I work with creditors, it comes in my way. Can you talk about valuation, please? And to what extent did it play a role in your decision to be a resolution applicant? And this whole concept of liquidation value, what does it mean for you when you're acting as a creditor? Does it help or hinder you? When you're acting as a resolution applicant, does it help or hinder you?
See, being fair to the process, every lender would like to have a benchmark threshold with which he can actually work on his recovery process. So in that sense, having a liquidation value, whatever be the timing of it, it being on the insolvency commencement date, that, I mean, whatever be the drawback of it, having a set number with which you start with is a better thing to do rather than having nothing at all. But the point is, in a sector like ours, the liquidation value is so much lower than the fair value. For example, the replacement value of having a PPA or a FSA in place, and it can't be actually gauged in terms of liquidation value, because the quantum of money, time, effort that we put into getting those kind of intangibles is much higher and can't be realized just in terms of a liquidation value. So that is the constraint that always is faced by all kind of lenders, whatever be the sector they are in. But still, it is always good that there is a kind of benchmark that they start with. And the reason why we got into this process, that too in depth, is because of the major drawbacks of the bids that we are getting. I mean, maybe it's all near the liquidation value and it looks all good. But the point is the kind of effort that we have put in it, our understanding of the valuation of it, there is a huge disconnect. Primarily because you have to understand, I mean, the fair value of these assets is primarily the replaceable value. And that goes around like 9 crores per megawatt. And the kind of realization that we get is like 1.5 to 3 crores per megawatt. There is a huge difference. And primarily that is because the kind of bids that are coming in is quite limited, right? Secondly, they are also doing a kind of deep discounting because they know the value of it. They know that this is the value that they will realize post the process is done. But obviously, because it is all a buyer's market right now, so they kind of quote the numbers they got. And that is the reason why, if there has been specific cases, we have ourselves pushed ourselves into the process and become partners with the bidders or with the successful resolution applicant. So as any upside from the process, after the process is done, also accrues to us.
So, Mani, if I were to speak to any lender today and ask them, would you like to trigger an asset into insolvency? Yeah. 5 years back, in a lot of cases, the answer would be, yep, this is the solution. And today, if I go to any lender on any asset and ask them, would you like to trigger insolvency? The answer invariably will be, no, takes too damn long. Invariably, right? And we have a bunch of changes in the code, which I guess are going to be going to be placed before our legislators, right? I guess it'll be placed in the monsoon session if I'm not likely to be. Will this help? And the answer can't be yes or no. Please tell me why.
No, I never give one-line answers. That's only for cross-examination. See, timeline-related stuff. We started with 180 days plus 90 days. Then we moved to a 330 days. Then the Supreme Court said, oh no, mandatorily is not, in accordance with the constitutional scheme, struck it down. I think timeline is something that will have to be looked at by everybody involved in the process to see whether it adds value or not, right? And therefore, there is a need. See, even 330 days is sufficient as long as we can shrink the number of regulatory processes that we have to do. And that also brings me to the point of capacity building, right? So today in the proposed agendas for reform, we were talking about two things. We're talking about the fast track insolvency resolution process, and we are talking about broadening of the pre-pack insolvency resolution process. Both are intended to, in some ways, save time. But ultimately, I feel that strictly I speak as a litigator, right? And what I see in courts, if every single thing is going to go back to an adjudicating authority that is overburdened, that is understaffed, it doesn't lead to any value creation for anybody. Everybody loses in the process. And in the morning, one of the speakers put a number to it, right? And the number was 1.8% per month is the deterioration in value. And I can tell you as a matter of fact that we've seen situations where resolution plans have not been approved for 2 years in a row for no fault of the RP, without having anybody challenging the plan, but simply for lack of capacity building in the country at the tribunal level also. And I think that is something that needs to be addressed while we are also, adding new pathways to resolution and new terminology in all of this. We need to address the issue of capacity building squarely and upfront.
Yeah. Rajesh, I'll actually add a couple of more points to that. I think generally, as you see across the world, at least in the mature economies, insolvency is only one route to debt restructuring. There tends to be multiple routes. The reason people don't go for insolvency as the first sign is usually there is a significant cost to it. There doesn't seem to be any cost to litigation in India.
Yeah.
It's a free option. If I'm sitting around with, 10,000 crore debt stack, bids at, call it 3,000, 6,000 and 8,000, I don't mind spending 10 crores or 20 crores in a litigative process to just railroad this process. It is a fundamental problem that we need to address. And what other countries do to address this is to say that you, petitioner, have won the matter, therefore the respondent will bear your costs. You, respondent, have won the matter, the petitioner has wasted your time, so he is going to bear your costs. Now, that immediately signals a huge change because people don't just go on appeals willy-nilly. So I think one big change, and that's just got nothing to do with IBC. Yeah. That's got to do with our judicial process. I'm just picking up on a point that Mani made because capacity is one side of it. But capacity can also be clogged because people have the ability to clog it. I want to get rid of that ability. And there has to be a cost. The cost doesn't need to be financial. Every time you get your name out in the paper saying so-and-so industries had to bear the costs of so-and-so, it's a reputational cost as well. If I'm a one-shotter to the system, I take that one shot, I don't care. Patta. If I'm a repeat player in the system, I don't want the system to think of me as a frivolous litigator. Yeah. I need the system to also respect me. So if I'm a repeat player, and chances are each of our industries, each of the bidders, each of the lenders, they're all repeat players in their context because they don't just do this one time. They do it hundreds of times. As an institutional capacity, institutional experience, it's significant. So I'd seriously add that additional element of costs into this process. And I think that will help in pushing some of this down. The second point, which obviously Mani also made, was around she alluded to it. The SR judgment was very clear. Please don't come along challenging things in courts until you get a plan, until the plan is passed through. Don't waste time, right? Why is our NCLT not listening to this? This is not me giving them the lecture. This is the Supreme Court of India passing a binding judgment on them. the NCLT should not be entertaining applications from potential resolution applicants, from challengers to the process. I'm a public interest litigant. I think this is going very, very wrong. Please come and help me. These are not the kind of people that the Supreme Court wants intervening in this exercise. So that I would think is the second point. And that is nothing needs to change. All we need to do is implement the law, because the Supreme Court has been very clear on this issue.
Yeah. No. I couldn't agree with you more. And Mani, I was also very relieved when you talk about the 1.8%, 1.8% per month. One of the few losses that we haven't attributed to the RPs. So I think the RPs will be very, very relieved to hear that. But Veena, anecdotes. There must have been things that have worked, right? There must have been situations that you're aware of that have worked outside the courts. Both parties or multiple parties walked away happy. There must have been.
Happy, I don't know, but there has been at least one. If I look at successes outside of IBC, I want to talk about one specific case, and the reason I want to talk about it in this forum is because everybody talks about priority lending, last mile financing, right? Lender comes in with the obvious expectation that that lender will be repaid first. So we had actually a very interesting case where IBC petition was filed by one of the existing lenders, and the argument, we were acting for the priority lender in that case, and the argument priority lender was making is, your payment may be due, but it is not payable because I have not got paid. And
sorry, it wasn't Prashant, was it?
No, it wasn't Prashant. So, and there were 13 other public and private sector banks involved in that case. And the NCLT kind of agreed, but didn't really opine on this. They just postponed the decision. But in the meanwhile, the escrow bank appropriated some money and paid it to the other lenders, or distributed it proportionately to all lenders, by which time the priority lender had also accelerated the loan. Interestingly, this came before the Bombay High Court. And unfortunately for us, we don't have an order. But Gautam Patel said, if you don't respect contract that you have signed, which is that the priority lender gets paid first, I will pass an order and all 13 banks will be named in the front page of the newspaper. So it got settled and our client got paid. So they were happy, but at least respecting priority is a matter of, it's a matter of concern today. Anybody who comes in, right, whether it is in insolvency as an interim finance provider, where you at least have statutory protection, but if you are coming just pre-insolvency to provide the last mile financing, especially for real estate companies and things like that, till you don't know that I will actually get respected and I will get paid if things were to go south, people are concerned. And I think that's been certainly one of the positive developments. I think the other positive developments, the principle that has evolved is where in an outside IBC restructuring, promoters feel, and it's not just the promoters, even the lenders feel that everybody needs to bring something to the table. So everybody needs to have some amount of skin in the game to be able to say that, okay, this is a successful restructuring. Because if the expectation is that there are huge sacrifices by the promoter, or the expectation is that there will be a significant haircut to the lenders, nothing will work, because everybody is not with the same power matrix in the system, right? So a couple of things that have worked is back-ended payments to the lenders, so that the promoter feels that they have a stake. The lenders taking a stake in the company so that they get the upside of equity and they feel invested too. Those are the ones which have worked. In this, again, I think that players like Prashant, or for that matter players like ARCs, have played a role, because banks, fortunately or unfortunately, do not want to take those decisions for multiple reasons. A, it could have a precedent value. B, there is no basis to take such decisions? Is there a scientific formula basis which somebody can arrive at this kind of an analysis? There's no answer to that. These are more commercially driven decisions. So these are where things have been successful.
So I just want to check with the good people of the audience. Any comments, any thought? Oh, thank you. Yes, sir.
I want to know who drives the maximization of valuation and where does it start?
Sorry, sir, you care to elaborate?
Lenders are looking for maximization of wealth. So it's a repetitive process, or it's a objective process, mathematical process, or any lender can come up and increase the valuation curve. How does it work? Where does it stop?
Yeah. Sorry, I wonder if everybody got that, or would you like to repeat that question? Sure.
Yeah. Do you want me to repeat, please? Yeah. So my question is that how the maximization of valuation is decided, and where does it end? When do the lenders feel they are satisfied with it?
You're asking in the context of the code only, right? Code in the IBC.
Yes.
Yeah. So being a lender, I'll answer that. Then you can, yeah. So primarily, you may believe that it is some corporate greed that is making us push further on and get some better deal out of this process. But primarily, it is anyway net loss to us. It's not something that we are trying to actually maximize our gain. Actually, it is like minimizing our loss. And whatever happens, majorly what happens is we have already provisioned. If you look at all major lenders, they are getting to the IBC process maybe 2 years post NPA. By that time, they would have provisioned a lot of their value in these loans. And obviously, they are now looking at just going through the process to get it done. So if you look at it, it should not be some kind of value maximization, but getting it done with minimal loss. But what happens is the process itself is a great teacher. As you go through the process, you get your values done. You see the process itself is set. So you know that this is the liquidation value. Now this is the value that even your dissenting lender will be getting, even if it doesn't carry through. So obviously, the value on offer should be a little better than the liquidation value at least, right? Otherwise, there is no intent to actually go through the process when actually the dissenting lender is looking at better value. So liquidation value has a kind of importance there. Secondly, beyond all this thing also, since you are a lender, you have actually appraised it, you have a fair understanding of the strengths and the issues in the project. So you have a fair idea that what the valuation should be. For example, if it is a power project which has a set PPA, which actually has a revenue stream that is chalked out for the life of it, so you know that the present value at least works out this much. So either you take a call on that present value, and if you get the values, the bids much nearer to it, you may feel that yes, your value maximization is achieved. But true, it never happens like that. As I was explaining, everyone tries to deep discount so as their valuation improves from the process. So obviously, that is the reason why lenders are inclined to repeat it or look for a better value, so as and when they actually prod the applicant on, maybe they may actually get to that realization.
I'd just like to pick up a couple of more points, Praveen, and supplement this question. As another creditor, I also have a very a different perspective. I mean, in line with him, but I just want to elaborate a couple of other things that may not be really straightforward. The process is a market discovered value. Yeah, so that's very clear. But the market knows this process from before. The market wants to game the process. And we are very, very good at that. That's why we have this whole system of jugaad, right? So we are very happy to pick up the asset at the lowest possible value. That's the market's objective. The lender is trying to sell it at the highest possible value. Now, the one critical thing that the IBC does is it crystallizes claims on the insolvency commencement date. So when you say, what do you want from a value perspective? Obviously, as a creditor who's lent money, I want my money back plus interest. And if it contractually required me to get a default interest because he's not paid me for so long, I want the default interest on top of that. That is my expectation. Par. But the way the statute works is my interest clock stops running from the insolvency commencement date. So even if you think I'm getting 100 cents on the dollar, the reality is I'm not, because I didn't get interest from the date of the insolvency commencement. So when we look at lenders who are saying, oh my God, this value doesn't make sense, we need to run another process, you need to keep that at the back of your mind as well. One is the perception of value, the very important point that Praveen made in an earlier context around the liquidation value as opposed to the replacement cost, right? That's the more critical thing. How much will it cost to bring exactly the same asset if you were to start from a standing start? The second point I wanted to make is that, look, lenders are also very conscious around what is happening, right? Most lenders know exactly what they think is the price at which they would vote yes and move forward. Because making the right decision at the wrong time is the wrong decision. So we all know that, right? So we don't want to just keep postponing because that impacts us directly. But at the same point in time, the drivers aren't just creditors who are just being rational and economic in their thinking. Because in all of this, the largest players usually in an Indian CIRP process are public sector banks, are banks that have government stake, banks that have public money in them. So now you add a new element to it, which is, hey, I may like this value, but when I retire, and I'm not making significant money, when I retire, can I sleep peacefully, or will the Vigilance Commissioner come after me? So surprisingly, in most situations, the decisions that come into play may not be very rational economic at all, but may entirely be driven by by a fear of persecution. So that's the point that was also made around the fear of prosecution. That I think is another very, very important nuance in our context, which is not necessarily seen in other international jurisdictions. I think that it should be a finite timeline. I think they should run as many processes as they want during that finite timeline. And when that timeline comes to an end, the process should stop. But the reality is we are working in a dynamic setup. Insolvency, one size does not fit all. And therefore, we have to keep evolving the process as we go through it.
That means the timeline, extension of timeline is not a correct thing.
I don't disagree, because from a creditor perspective as well, there is a cost when the timeline is extended. Because as I told you, my interest clock stopped. So it's not like I'm getting more money at the end of it, even if there's significantly more value, because my interest clock has stopped.
Public sector banks would like that. Somebody will
there
are multiple cases which are like, since I have been fortunate enough to see it from 100 crores to 20,000 crores. Now there are cases, if the timeline will be finite, what compliances, what due diligence you need to do in a case of 100 crores, the number of operation, the scale of operation, the number of, for that matter, let's take EPFO department for that example, the number of employees that are there, it needs time to check all of it. And if the timelines will be finite, say 330 days and it is over, that's the end game for you. That's the end game. So that's not how the entire process will able to work, because ultimately we want a fruitful resolution. If the resolution will not be fruitful, if there are still some compliances left, if there are still some ambiguities left, it will lead to the future litigations.
So I think the important point to remember is the value doesn't come from ether. It comes from the market. If the market knows there is a finality to the process, chances are the market will price the right level. Now, I cannot argue with the point that you made, which is that there could still be ambiguities in the plan, there could still be issues that are unresolved. But look, the whole premise of this legislation is that somebody wants to buy this asset on an as is, where is basis. If you, because your department is so big and you have to run 100 people through the process and get them up to speed before it goes up to a stakeholder committee that will finally say yes, end up taking more time, that is your loss. Or indeed, that may be your gain because you decided not to take that asset and it was the right call. But the process can't wait for every single creditor. The process can't wait for every single bidder. The whole idea is that we need finiteness in this exercise.
Basically, you can't think of maximizing too many points. You have to focus 1 or 2 points.
It goes back to the principle of resolution versus recovery, right? I mean, we keep saying that the idea of IBC is resolution, but everybody sitting in a COC is looking at recovery. So it doesn't matter what the paper says. At the end of the day, the interests are not aligned with the statute, and that's where the mismatch comes in. Yeah.
So you had a question?
We are, as I'm harping on this point of recovery. You know, in India, a criminal can become a lawmaker. Okay. Why a genuine failure cannot be given a second chance? That is one thing. And, you know, even judiciary gets 6 stages are there to correct one order if it is wrong. If the first stage. Why a entrepreneur cannot be given a second chance? A genuine failure.
I think that's a fair ask, and I would be comfortable agreeing with that point.
Yeah.
See, I think 29A came about because of the fact that there was a fear. There was a fear that promoters would come from behind and take it. And it also came about in circumstances where the borrowers themselves seemed, I'd be very careful around this, seemed to have suffered some frauds within them. There were suggestions and allegations that the promoters had lined their pockets with money, which should have otherwise been that of the company. So that was the genesis for this. I think you made a very valid point. And using the hospitality cycle point that Praveen made, if I had nothing to do with the hotel was running properly, I haven't stolen from the hotel, but the hotel stopped functioning because there were 2 years of COVID. Nobody came to my hotel. There is no chance I had to pay my employees. There's no chance I'd have had to pay my creditors. At some point in time, I would have had to go into an IBC process. As a promoter of a hotel, and I didn't do any fraud. I didn't take money out of the hotel's books. What happens now because of Section 29A is that I can no longer bid anymore. And I think that's a fair question, because in this situation where the failure is come out of business issues, cycle issues, gross judgment flaws, right? You can make it. You're entitled to make mistakes. I think that maybe the legislation should be tweaked a little.
Was one case.
Yes.
You know, where the entrepreneur was not at a fault. Like in my case, 64% value of material eroded overnight. Okay. So where do we go in that case? That is one part of it. Secondly, you know, and I'm very vocal about it, is that entrepreneur today suffers from trust deficit. He is considered as thief, you know. That is another major issue. And I don't mind saying in open forum, because I had expressed my dissent to the Chief Justice of India also in writing. In one of another cases, not related to NCLT, my file was thrown by a senior judge in the court saying that all entrepreneurs are thieves in the country. So that is the perception we are carrying. That perception has to change before, you know, we go.
So just to add a couple of thoughts to this discussion. See, I think the legislator also recognizes that mistakes happen, or, you know, business downturn can affect any industry, any sector. And that's why if you see at this moment, the pre-pack insolvency keeps the promoter in control. Now, the issue is that when pre-packs were originally being discussed, it was not restricted to MSME, but the final form of the statute saw it as being restricted to MSME. But today, I think there is a discussion, there's a consultation paper to extend it to other sectors also, and to other non-MSME industries also. And I think that's the government's way of signaling that, look, we understand that mistakes can happen, and in genuine bona fide cases, we will let the promoter retain control. So I think that what you're feeling, sir, your pain, I mean, I've seen you since morning today, there is a genuine hardship that you have suffered. I think that the government's also aware of it. I don't think that there's anybody here who doesn't.
No one is aware.
No, sir, I don't think that there is anyone who is. See, obviously, we can't feel empathy for any other human being. but we can certainly feel sympathy. And I think that the government feels it too.
I think my take on this, I think the market is a great leveler, and a lot of these things settle down over time. If you ask Praveen today, in between jail stints that he does, if you ask him, are the lenders today trigger happy on filing a Section 7? I hope I got the section right. On filing for insolvency, where they know that the sponsor is trying his best and where there is a possibility of resolution, would you just trigger insolvency for the sake of triggering insolvency? No. Sorry, I'm answering your question, but would you do it?
I'll answer it. I'll tell in plain numbers. My recovery overall is like 63% across all cycles, whether it be through OTS, restructuring and everything. And my recovery from IBC hovers around 30%. It ranges from like 17% to 100%, but average is like 30% only. So even from my perspective, I am not that keen to get into a process wherein I lose my control of how to get about resolving this asset, and I don't have any idea about the quantum that I have to forego and how much time I'll take in doing that also. And if that asset is something like it's a dead asset or a stalled asset, then I need to even bear the cost of it. So it is like a decision making in these cases is like total 360 degrees, understanding the pain points and looking at the best way forward in such a circumstance.
Thanks. I think we had a question from the table there. Yes, please.
Hi, am I audible? Yeah. So I'm asking this question from an investor perspective. What can an investor do to safeguard his interest when acquiring something through IBC process or through the resolution plan process? Because although the resolution plan does mention that this is final and binding, but there have been instances where other claims, especially the statutory claims, have been raised and contested in the courts. So how can, as an investor, and also there are some litigations which keep on going. The tax authorities and the CBDT, etc., keep raising some issues after the asset has been acquired. So although on paper it's binding, but and often the investor is, in a way, they don't have an option but to settle those number of those small amounts, move ahead with life. So how can an investor in such situation avoid such leakages, if I would say?
I'll give you one practical solution, which is from the distribution, keep a corpus aside before the distribution is made to lenders. Keep that corpus for litigation expenses, which even a resolution applicant who has come in or an investor who has come in to the company can be subject to, right? Keep a corpus. We are aware of cases, the top 12 cases, at least 4 of them have crores and crores of corpus set aside just for this purpose. I'm not saying this because I'm a lawyer, but it's not just for legal cost. It's for the time value also. It gives you certainty. It's not your money because you took the company on an as is where is basis. As is where is did not include litigation risk of this magnitude or this timeline that is involved, right? So that's one thing that you should do practically. The second thing to do is probably get it documented to the extent possible, because some of the things, more than what you are taking over, what you're not taking over is actually important. So the resolution plan itself being clear on, not being ambiguous, but being clear on what will not be entertained. And obviously that is a very asset specific related analysis that you will have to do. That is also important, is what at least we have seen from an investor's perspective.
Thanks. Anyone else wants to raise a point?
No, when you say it will not be entertained, but how does it stop somebody to file a case against?
It doesn't. Unfortunately, it doesn't. That is why I'm saying that, because you can still price that and at least keep it.
Just a clear law. Yes.
Yeah. Litigation in this country has no downsides. That's the problem. Free option. Okay.
20,000 rupees will give you a litigation, and then you can.
Okay. So I understand that we need to close out by 4:30 p.m. today, and I have personally been threatened with some very dire consequences if I don't finish on time. So I thought I thought I did want to raise, you know,
beyond 4:30. We're curious to see what those consequences are.
Yeah. Come on, we're in this together.
That has already come, so we're good.
you know, all of this has been about how do we get the money in to resolve an asset, right? And then I think we're now going to see the next part of the life cycle is how are people like Prashant and Praveen going to get their money out? So let's start with Praveen because I really want to put you on the hotspot. You're a resolution applicant. You've acquired your first project. You're a potential resolution applicant in more assets. I do hope. I wish us all well. You may be a successful resolution applicant. You'll be operating these assets, and someday I presume when the cycle turns, actually the cycle is already turning in power. You may want to liquidate. What's the plan? What's the end game? Where does this lead?
It isn't essentially ours alone, but the objective of the government also to monetize an asset once you actually recover the value. So ours is not actually totally different from what the government is saying. So herein also the justification that we are putting up is that the value realization is not satisfactory. And as and when there is the cycle, and also see the value building in this exercise is primarily from it need not be from capex alone. It could be by just running the plant and getting the contracts in place rather than putting a new capacity or anything like that. So value creation can happen in multiple manner. So each specific case has its own distinct value creation capability. So we'll be using that, and the process itself right now states like there is a 2 years hold on. So beyond that, once there is an improvement, we'll surely monetize it.
And Prashant, what is your view? What is your view on how easy it's going to be for global investors to monetize over time? There's many situations. We actually have and you know, this happens sort of behind the scenes because there are many transactions that a lot of people at large will not come to know of. But there's been so much deployment that's happened into debt, right? What is the end game? Where do you think it's going to be? Have we started that cycle yet? How easy is it? How difficult is it? How do we compare globally when it comes to exit? And all of this in 30 seconds, please, because I'm still facing those dire consequences.
I'm very motivated to get you to face those consequences, so maybe I will take a little longer on this one. I would say that, look, we've actually gone through several cycles of private credit coming into India in a big way and having that money exit out as well. You tend to see the situations where things go wrong and those come out by way of litigation and so on. The reason you don't see too many success stories is because it's actually successful. There's nothing to talk about. The guy gave money, he got his interest, he got his loan, and he said, thank you, and he took it out. That was it. And the biggest place that you see this very, very constantly is in real estate. Residential real estate, I mean, think of any of your large developers, Lodha, Raheja, Century, Purvankara, Brigade. All of these guys have had investments that have been made by credit investors. They usually use the simple route of the non-convertible debentures, NCDs. They subscribe to NCDs using vehicles which are permitted to do that, foreign portfolio investor vehicles. And they simply have a very comprehensive security package supporting it. The security package is basically every time somebody goes and buys an apartment, the cash goes into the escrow account, and from there, a portion of it goes across to pay down a portion of the debt. That's just a simple process that goes on. There is significant motivation for the developer to get that out of the way because usually the credit is supported by at least anywhere between 50 to 60% LTV. So it's either 2 to 1 or 1.6, 1.7 to 1. So there is significant equity still left after the lender gets paid out. And the quicker the lender gets paid out, the more the equity is because you aren't paying that interest cost to the lender. So that has been a tried and tested structure. You have seen enough litigation around it. You've seen borrowers do all the inventive stuff. No, he didn't take FEMA permission to do this. The high courts have said, sorry, FEMA permission is simply a foreign exchange restriction. You still have a contractual obligation to pay this chap his money. Please pay the money. Let him deal with the RBI in a separate context. There have been situations where lenders have actually enforced the mortgage, sold the property, converted it into rupees, got the rupees to pay them down. So this is tried and tested. So I don't see a fundamental difference between anything lacking from that perspective. What I would also add is that from a comparative perspective, I think at least from an APAC jurisdiction standpoint, which is where we tend to invest, I think India is in a very creditable, kind of mid to top rung level in the jurisdictions for getting your monies out. Probably not as easy as a Singapore, Australia, or a Hong Kong, but definitely not as hard as an Indonesia or a China. So I think from that perspective, there have been good steps that have been taken. So I don't see any reason why people who are able to price it properly will not take a view. The only final point, and I am a lawyer by background, the only final point I would make is these decisions are not legally driven. They are not enforcement driven. The decision to invest is almost always 99.99% credit driven. It's only that 0.01% that people keep in the back of their mind for what happens if things go wrong. You don't go in expecting things will go wrong. I mean, you do as a paranoia, but if you think that that is an outcome, you will just not invest there. So I think fundamentally the credit decision is the critical one that will keep you, and every one of us has different views. A stressed investor, a stressed credit investor will have a slightly different view from a performing credit investor who will have a different view from a scheduled bank, and so on and so forth.
So I think my 330 days are almost up. So I'm going to give the last words to Mani and Veena. Any one or two big points that you'd really like to highlight in summary?
Okay, what I'm about to say is going to be controversial. Sorry, Veena, I'm going first. Is slightly controversial, but this is something that I have seen in my practice, and I think it raises issues of justice and how legislations need to, yes, certainly see guiding lights are perhaps more established jurisdictions, but we need to also localize the context. One sticking point in the IBC that really hurts a lot of businesses in India today, and we're in a CII conference, so I think I can safely say this, is that the operational creditors, right, they really stand to lose, because once at the end of the day, if there is a resolution that has happened, what they end up with is a liquidation value which could be close to zero, is almost always close to zero these days, and all their rights to take up any litigation in respect of a breach of contract is also extinguished. I think that IBC has been kind of landmark in the sense that everybody's talked about the behavioral change between lenders and borrowers, and the regulator has also seen a behavioral change in the sense it's reacted very proactively to change. But I think that one more behavioral change we need is that if you are an operational creditor, okay, you can no longer put your head in the sand and pray that everything is going to be all right. You need to perhaps look at becoming a more litigious operational creditor. And simultaneously, I would say that the IBC perhaps needs to be tweaked, okay, to take into account and give some sort of priority and some sort of relief to those operational creditors who have really kept the CD going as a going concern in the twilight zone. See, every promoter knows at least 6 months, a year in advance that they are in financial trouble, right? And there will always be those operational creditors. It could be an auditor firm, it could be a legal firm, it could be the guy who supplies your cement to your real estate project, who keeps you going in that twilight zone. Those guys getting zero, those guys being rendered not, is, I think, a problem of justice. And I think that although it is, what I'm suggesting is contrary to all the other jurisdictions' waterfall mechanism and our own, but it is something that we certainly need to look at, given that we have a very large industry established as MSMEs who would also then feel the dominoes effects of this.
I raised this point in the morning.
Yes, I understood, but you were saying unsecured creditors, so वो उस तरह से समझा नहीं गया था.
Lifeline, last 6 months की lifeline जिसने दी, he is the biggest user.
See, this issue now happens to the best of us. For example, there is power grid.
Yeah.
Without it, any power plant can't run. But still, at the end of the day, when it goes into CRP, Power Grid is one of the OC creditor out there, and he'll be saying that, but for me, this generation or this power sale wouldn't have happened. But still, there is no differentiation there. And if we settle something like that, then the queue will be quite long. It's not that simple.
I'll just make two very quick points, Rajesh. I think one is the need for closure. When we look at IBC generally, and whether it is from the perspective of the investor, promoter, any situation in stress is bound to have somebody who is left unhappy in the process. Somebody has to be it. You cannot make everyone happy in a stressful situation. That's a fact of life, right? From just a change perspective, there has to be a closure, and that is something that we need to work on. And the other point I want to make is judicial activism. I mean, we have seen that one bad judgment can set aside months and months of progress that has been made. So to the extent judicial activism can help, that is certainly something that I think needs to change.
Can we have a round of applause for the panel, please? Thank you very much. You've been a very patient and very collaborative and very supportive audience. We really appreciate seeing you here. Thank you very much. If you have any questions for the panelists post this program, they're here. I need to be off. Thank you so much. Wonderful to see all of you.
Request everyone to please join us for tea.